I don't cruise the internet, certainly not during a trial, but I am told that there are TikTok messages that if there's not a conviction in this case, that the courthouse will burn. I know that that's of concern to everyone. There are, yesterday, the third piece of paper, which is a dark text message, was received by a member of my client's family, and they sent it to me immediately and made no response to it. But it's alarming because it represents the other pole, what I would call the skinhead white supremacist, that lunatic fringe. And, Your Honor, in the middle, as we have said, the narrative in this case, beginning shortly after the incident, hasn't been helped by the statements of public officials. I've attached that, but it's already a part of your record elsewhere. And then I've highlighted a portion of a news article, which I won't read because I've highlighted it for you, but it suggests that somehow this trial, instead of being a fact-finding mission resulting in a neutral, detached jury's deliberation and determination of guilt or innocence, is somehow a moratorium, and that justice will fail if the event that this journalist seemed to suggest is the result that should be obtained. But, Your Honor, for all those reasons, we rely on judges' instructions. We hope, we keep our fingers crossed that juries will take that to heart, that they will avoid interference, that they will report it to the court. But we know from the Murdoch case, that just doesn't happen. Now, that case is different because it involved the interference of a court official, one who, as our Supreme Court said in that opinion, was the court's representative. So the jurors could have easily felt, as they did in that case, that it was okay because that was the court's caretaker. But I think that there is the very real potential, given the amount of publicity attendant to this thing, Your Honor, that I would ask the court, though it is inconvenient, it will take 10 minutes, and I would not oppose you, Your Honor, going to the jury room and pulling them one at a time out in the hall. I don't know that we even need to be present. I don't know that the prosecution will have a position on this, but I do think it's important not to poll them as a group. I think it merits, in order to assure a fair trial that is free from any taint, interference, suggestion, even to the extent of driving by the state capitol this week, you're likely to have seen a poster. And I don't want jurors to think that they're getting themselves in trouble if they have seen something that may have caused them to think in an inappropriate way. But I do ask, Your Honor, with all respect for the time and the economy of time, but I think it is that important. Thank you.
Thank you.
Your Honor, I don't think we need to bring any additional attention to this matter, Judge. I mean, the things that Mr. McCullough has brought out, I mean, I appreciate the fact that he brought it to our attention, but we can't control what the outside world does. And I mean, posts by people who are not involved in this case, that we had admonitions that were given, and to our knowledge and what we know is the family's done everything they're supposed to do. They've not posted, they've not engaged, they've not done any of the things that the court has asked them not to do. What the rest of the world does outside of this courtroom is what the rest of the world does. What the rest of the world calls us, calls prosecutors, I really don't care. You know, we're here to do justice, and that's why we're here now. To ask the jury to do something additional now, Judge, if they've got a question, they have the ability to write it down. They got the ability to say, hey, Judge, this did or didn't occur or whatever. And to my knowledge, that's not taking place. So in order to pull them out and start kind of poking and asking, you know, specific questions of them, I just don't think it's proper at this point. We've had other high-profile cases. We've not done it. We didn't do it in the Uber case here. We didn't do it. I mean, it's not been done that I can recollect. I'm not almost 30 years of practice in law. I've not had a case where that's happened, and I don't think that we need to start doing it now. If the jury has a question, they understand your admonitions. These are grown folks who went through the process. They've adhered to everything that you've asked them to do at this point, and there's no need to start pulling them out and searching for something when they're not telling you that anything is going on. I don't think it's proper right now.
Your Honor, I would simply say that as I mentioned, we sequestered juries for many decades. And we did so at a time when the only access that jurors could have to taint themselves were much less than today. There were 3 TV stations. There was no internet. There was no social media. There were neighbors. And those opportunities were the only opportunities to be tainted by public opinion. And yet, for 3 decades or 4, our courts sequestered juries. To the best of my knowledge, we stopped doing that because of the expense. Okay, I get it. But today, 1,000 television channels, social media platforms that allow the worst and most scurrilous, degrading, disgusting conversations, even to the point of threats of violence and threats of destruction. That is so ubiquitous, Your Honor. And I think, I don't know that I recall making a motion like this, but having gone through the crucible of the Murdoch case, I recognize a couple of things. The frailty of a jury's willingness to come forward. And that's a human nature. It's not a dishonesty on the part of the jury. It's just a belief that it doesn't need to be reported. So I would ask again, Your Honor, while it may be novel, but I think it is necessary. And the mere fact that it hasn't been asked before of you or another judge, whether in this courtroom or another, I don't hesitate or have any embarrassment about asking you to do it now to ensure against the possibility that any juror has been contacted or otherwise stumbled in to the receipt of information. Thank you.
All right. Well, I'm on your position on that, Mr. McCullough. I don't think there's any real procedure for doing that, and I see it as fraught on a number of levels. If I were to go back there and examine each juror individually myself, again, based on what we learned from the court's ruling in Murdoch, I am hesitant to have any sort of conversation off the record outside the presence of all the lawyers with any juror. So I will deny your motion in that regard. What I am going to say, though, too, is the stuff here that you provided is troubling, although there's been a lot of troubling things all weekend. Lawyers, and I guess I'm more talking to the public here, we just all need to turn the temperature down, much like I cautioned the lawyers Wednesday to turn the temperature down. The public does too. This matter is actually only a matter of life or death with the Carmack-Belton family and the Chow family. The rest of the folks don't need to be sending messages like this to lawyers. I actually got emails myself over the weekend, which reminds me I need to send a sled. Please, folks, just turn the temperature down. There will be a verdict maybe here today, and we're all going to be respectful of one another. And I want to commend everybody that's been in this courtroom for the week, or all last week. Everyone here has been respectful to one another. There have been no issues, there have been no outbursts, and I commend you all on that for being respectful of your neighbor. But we're going to continue to do that, and that's how today's going to play out. So, with that being said, what else? Jury charges.
Yes, Your Honor. I think we just have 2 quick issues to bring up with regard to what the defense's position is with final charges. We did send an email to the court yesterday afternoon with the 1 edit and the 1 addition. First of those would be to add within the element about bringing on the difficulty. Our position is that the language and the court's draft, the cleanest way to make this edit would be at the bottom of 16 going into 17, that if the conduct of the person defended or the defendant was unlawful and of the type which was reasonably calculated to and did provoke a deadly assault, and continuing from there. In support of that language, we're relying on State versus Bryant, 336 South Carolina 340. That's from 1999, and that exact language was reiterated in Slater, and that's 373 South Carolina 66. And the direct quote from those cases is that any act of the accused in violation of law and reasonably calculated to produce the occasion amounts to bringing on the difficulty, and would bar his right to assert self-defense if those conjunctive conditions are met. So that would be the first request that we'd have. And we also do believe that the evidence adduced over the course of this trial does squarely put the issue of withdrawal in front of the jury, and that is a question that they must decide whether. I don't think it's going to be any surprise that the state will argue that Andy Chow and or Rick Chow were at fault in bringing on this difficulty. With respect to the testimony that we have received over the course of last week, Andy's conduct, his act, the jury could find that act amounts to a withdrawal from any potential difficulty the jury may have found he had brought on. And if that withdrawal is effective, then his right to self-defense, and by extension, Mr. Chow's right to defend him, would be restored. And in support of that withdrawal charge, the language of which is one's right to self-defense is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. And that or act portion was emphasized, I believe, in State versus McCarty as 437 South Carolina 355, and that is also quoting the Bryant case at 336 South Carolina 340. We do believe that the withdrawal law does need to be charged to this jury in light of what's been adduced over the course of last week.
Continue to state.
I just don't recall any testimony regarding any withdrawal. This was one continuous act, Your Honor. I don't remember any testimony whatsoever of withdrawal. It was a chase that went 130 yards, and there was some backing up that was testified to, but it was right at that moment. This was a bam-bam kind of situation the way it was described.
Okay. Here's what I'm going to do. I did look at all this. As far as the violation of the law language, I'm not going to charge on that. I think the implication of that charge would mean that there would have to be a violation of the law for someone to be not without fault. So I'm not going to put that in there. I am going to add the language of withdrawal, and it is in the final charge. It will be on page 18 at the bottom. And here's the exact language. It went a little further than what you asked for, Mr. Copeland, because I think you sort of cut it all short. Here's the exact language. One right to self-defense or defense of others is restored after withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. So went a little further. Then just, I guess you pretty much had the first sentence, but the model charge that we have added, that basically it has to be essentially unequivocal that the person defended is withdrawal. So that's how I'm going to do it. Y'all have been emailed a copy of the final charge as well. Anything else?
Are you intending on, or have you thought about, we're going to send the instructions back with them initially, or just play it by
I typically do not, and I will let them know that if they have a question about the law, the procedure for that would be to send me a note, and then I can recharge them on the law. I just get concerned that folks, this is intended to be interpreted as a whole, and I get concerned that folks one person relies solely on page 17 and nothing else as a whole. I don't know whether I'm right or wrong. I know some of my colleagues send the charge back, but that's the way I am. All right, you ready for closing?
Yeah, a little PowerPoint here that's just going to have some, so Pat has the thing ready whenever. I know it takes a little time to fire up.
Okay.
Pat, if we have it, will it just turn right on whenever we're ready for the first line?
It has a little delay, so,
Okay.
yeah.
And as you can tell, the document you gave me, you give one to the court reporter, you mark this court on.
I did not, Your Honor. I just passed it up to you, but I'll be happy to come up and hand it out.
We made this one, of course, tonight. All right, Rick.
Yes, sir.
All right, making sure, please, sir. Yes, sir.
Jury seated, Your Honor.
Thanks, sir. Good morning, ladies and gentlemen. Good morning. The parties have presented all the evidence in the case, and it's now time for the attorneys to make their closing arguments. Much like the opening statements, the arguments of the attorneys are not evidence in the case. Their statements are meant to help you understand the evidence and apply the law. You should disregard any remark, statement, or argument which is not supported by the evidence presented during the trial or the law that I'm going to explain to you at the conclusion of the argument. Stay ready to close.
We are here. Please, Court.
Yes, sir.
Thank you, Your Honor. What is the value of a human life? That's usually posed as a rhetorical question, isn't it? What is the value of a human life? Can we assign a monetary value to a human life, to a human soul? We put a price on it, like we can a bottle of water, or a bottle of motor oil, or a lampshade, or a fishing boat. Is that possible? Are some lives worth more than others? These are philosophical questions that people have been wondering aloud for ages. Do you remember that feeling of being a teenager? You remember what it was like when your body was new and shiny? Remember that? Remember time before work and bills and all the responsibility, being responsible for other people? You remember that feeling? You remember what it was like having that long road of life just stretched out before you, and all the possibilities. Not knowing what they were, but just being excited for the ride. You remember that? Remember the last day of school? Remember the beginning of summer break, sleeping in, summer jobs, fireflies, fresh peaches? What about grandma's house? Slip and slides? Remember the smell of fresh cut grass? Beach trips? No responsibilities. How do you put a price on that? You remember that? How do you put a value on that? I've got a 15-year-old daughter and an 18-year-old son, and they're in that time of life. And if I'm waxing too poetic, it's because I'm envious at times of them, and being in that stage, and just having that whole long road of life stretched out before you, and all the possibilities. Just an adventure waiting to unfurl, right? But if I could jump in a time machine and go back to them being 14 years old, I don't think I would, because I remember the difficulties of that time as well. I remember being 14, and a sad reminder that I'm not anymore is sometimes when I get a glimpse of the camera and I see my face up there, and I say, who the hell is that? Where did those wrinkles come from? Where did that gray hair come from? But I do remember being a 14-year-old boy. And if I could, I don't think I'd go back to being a 14-year-old boy. Because I remember the difficulties of being a 14-year-old boy. I remember the idea of trying to zero in on what is my identity? What is my personality anyway? Who am I? Where do I fit in? How can I be cool? And to this day, I still remember things that I did that made me shake my head, things that I strongly regret, things that were ill-advised, things that were reckless and dangerous, things that were just plain stupid. It was not easy being a 14-year-old boy, and that was back in 1993. But that's what being a kid is. That's what being a 14-year-old boy is, to make mistakes and hopefully to learn from them, right? Isn't that what growing up is supposed to be about? I didn't look much like Cyrus, and I think that's obvious to everybody here. We grew up in different parts of Columbia. We had different experiences. We went to different schools. We grew up under different circumstances, different times. It seems that we were both skinny little 14-year-old boys from divorced parents trying to find our way. I remember trying to straddle that line between being a child and trying to figure out what it meant and where my place was in the world, and trying to figure out how to be a teenager. Trying to figure things out. And as I said, it seems that to me that it would be infinitely more difficult to be a 14-year-old in 2023 than it was in 1993. There are just things that exist now that were unimaginable back then when I was 14. But some of the broader challenges would have been the same. Where do I fit in? How do I fit in? This would have been that wistful time of life for Cyrus in May of 2023. He had just wrapped up 8th grade. We all know what comes next, 9th grade and high school and all the craziness of that. But right now, May of 2023, it's summertime. The first week of summer. What's better than that? How do you put a price on that? It's the best time of the year for a kid. There's still a few months before he has to deal with that crazy time of 9th grade and high school. Sunday, May 28, 2023, it was Memorial Day weekend. Cyrus was fresh off middle school graduation, and it was summertime. Why does a 14-year-old have a gun? This was asked multiple times by my friend, known him since I was 14, Jack Swirling. But he asked that a number of times. And I suppose he asked that as a literal question that deserved an immediate, succinct, distilled, and simple answer. That was how the question was posed, that it is a very simple question and deserves a simple answer. Maybe it's not that simple, though. Maybe it's a much broader question that we as a society will eventually have to sit down and come up with real answers to and possible solutions to. Maybe it's a question with an answer that is so complex, it has so many layers, that it's so loaded that maybe it's not something we just figure out in a day. But it does seem, as long as guns have existed, boys have been fascinated by them. Required reading when I was in elementary school was Where the Red Fern Grows. And it was all about Billy and his gun and the exploits and the adventures of 10-year-old Billy and his rifle. Or, my favorite movies back then were Tombstone and Young Guns and Predator and Terminator. Just movies about guns and violence. Boys eat it up. I did. So many movies, so much imagery, so many music videos about guns. It's just, we're in America. It's part of life, and boys eat it up. You can't even get through December without Christmas Story and Ralphie and his fascination with the Red Ryder rifle, right? It's just a fact of life. And that was all before the internet. But again, we live in America, and to take that one step further, Cyrus and I grew up in the South. And we were blessed to grow up in the South, weren't we? And guns are just a part of life, are they not? A gun leaning up in the corner when I was growing up was about as exciting as a cast iron skillet on the stove or a butcher knife in the sink. It's just part of our life. And whether that's good or bad, I'm not here to talk about that, but guns are prevalent, and boys gravitate towards guns, whether that's good or not. Was Cyrus right in having a pistol in his pocket May 28, 2023? No. Was it legal for Cyrus to have a pistol in his pocket May 28, 2023? No. Has anybody indicated that it was okay or legal or right? No. Did he deserve to die? Did he deserve to die? I remember my grandfather letting me practice with a little .22 rifle. I remember being 8, shooting a .22 rifle. I remember my first single shot, .410 shotgun. I was probably about 12, 13 when I got that. I remember going up to the little cabinet just off the kitchen in my grandparents' house and finding a little revolver he had there. And I remember taking it down, and I remember going down to the pond and shooting a few shots. I was probably about 12, and I knew I wasn't supposed to do that. And I knew I'd get in trouble if I got caught. That didn't stop me. Remember all those things. Boys do things that are ill-advised and not always smart. That's part of life, though. We hope as we grow older, we learn some of these things and we grow out of them. Did Cyrus deserve to die? Cyrus Carmack-Belton entered that Shell gas station at 7441 Park Lane Road, about 8 p.m., May 28, 2023. He had no way of knowing that he'd be dead in about 10 minutes. You see him enter the gas station. He is immediately asked to take his book bag off. A very fair request, and he complies immediately. He's not rude during the encounter. He does as he's asked to do. We see Alice check the facial recognition database once he comes in. We heard about the facial recognition database they employ at the Shell gas station. And then she went about her business, or pretended to act busy, while keeping an eye on Cyrus as he walked up and down the aisles. At some point she ducks her head into the office where Rick is. What, if anything, she said to him is unknown. We don't know. But Alice and Andy continued to watch Cyrus as he walks up and down the aisles. Eventually he goes to where the water bottles are. He had to know he was being watched, right? I mean, I don't think Alice was making it unknown, or she wasn't really disguising what she was doing. He took 4 bottles of water out, put 4 bottles of water back in. He's caught on camera from several different angles doing so. And cameras do not lie. Cameras do not make mistakes. It would have taken about 17 seconds to watch him at that water cooler if Rick Chow had decided to do that. About 17 seconds of his time. 17 seconds to confirm that he took nothing. The failure of Rick Chow to do this will cost Cyrus his life. Thousands and thousands of dollars of technology at Rick Chow's fingertips, and he chooses to act in anger. Cyrus would be a rising senior if he was still alive, entering his 12th grade year of high school. If Rick Chow had taken about 17 minutes to review the footage. 1, 2, 3, 4. 4, 3, 2, 1. As Cyrus turns from the water cooler, Alice and Andy begin asking him if he put a bottle of water in his pocket. $1, 114 pounds, 130 yards, 21 grams. Fight or flight. You've heard that term. It's a physiological reaction, right? It's ingrained in us since we were cavemen, I guess, basically. And it is an instinct. It's a reaction that occurs in situations where there is a threat. Okay? If Cyrus is a tough guy, right? If Cyrus is a thug, right? If Cyrus is a gunslinger, right? If he is that guy, okay? If he's that guy, now is the time you'd see it. Now's the time he'd pull that pistol out, point it. If he was that guy, right? He's not that guy. He's a child. He doesn't pull out his pistol. He doesn't cuss or disrespect anyone. He collects his backpack, drops his head, and he walks out. If he was a fighter, now would be the chance for him to confront anybody. If he ever intended to use the gun, it would have been right here. But this is the moment where cool heads should prevail. cool reflection should be what happened here. Reflection should have occurred. This is when adults should act like adults. This could have been it. You could have walked off. You would be a kid looking forward to senior year in high school. You have a mother and a father who would still have their little boy. $1, 114 pounds, 17 seconds, 1 second, 21 grams. An entire lifetime ahead, unknown potential, success, failure, redemption, decisions. We know the decision Rick Chow made. It's etched in time now. It plays back like a bad movie you've seen before. You already know the ending. He did what he did, and that's why we're all here today. Let him go. Just let him go. We don't need to be here today. Let the boy go. What have you got to lose? What is the value of human life? As of May 28, 2023, Rick Chow had owned and operated that gas station for over 10 years. This was not his first day on the job. Why not call 911? It takes 1 second. Andy said so himself. It takes 1 second to call 911. Better yet, why don't we review the videotape? If we think the boy took something, why don't we look at that videotape? Because then we'd realize we don't even need to call 911. He never did anything. We would learn that immediately. All this at your fingertips. Instead, you choose to act in anger. You choose to make split-second decisions. And you're dead wrong. For argument's sake, there, let's say he had committed the abominable crime of stealing $1 bottle of water. Let's say he did that, okay? Well, you remember the wall of shame? You remember the testimony about all the pictures all over the store of various people who had been suspected of shoplifting. And what we do at the Shell gas station is we take their picture, because we have all these cameras that we can get all these pictures from, and then we put it up on the wall of shame. And that's what we do. We shame them. But also, if they come back in, we can confront them. Why don't we put this little boy's picture up there then? I mean, if he stole water, let's just do that. That would have been a better option, right? Or we get all these pictures, let's send them into law enforcement. Looking for this guy, and by the way, we know exactly what he was wearing, and by the way, he walked that way down this dead-end road. Shouldn't be too hard for you guys to solve. Anything would have been better than this. He chose to chase down an 8th grader. The boy was so terrified that he ran out of his shoe and continued running. The boy was so terrified, he's losing clothing. He drops his phone. He drops his mother's phone. But he continues running. But wouldn't that have been even another great opportunity for them to stop? Listen, we've scared this little boy so bad he's come out of his shoe. Let's stop the insanity right here. Let's turn around. Let's take our butts back to the Shell gas station. What are we even doing anyway? Why are we doing this? But no, they continue tracking him, chasing the boy down. And then he takes that hard fall, hits the ground. What about right then? Wouldn't that have been a good time to be like, we're scaring this boy so bad that he's run out of his shoes, he's lost his cell phone, so now he's hurt himself. We've gone too far. We've gone too far. But no. 130 yards, 114 pounds, 390 feet, 1 second, 17 seconds, 21 grams. Why in God's name are 2 grown men, one armed, chasing a child, because that's what he is, 130 yards? Why in God's name? Devontae Bryant, he had to hit the brakes because he didn't want to hit him. He'll come running out in front of him on Springtree. Dead set on catching that boy. He had to put the brakes on. He says he thought it was the police. I said, well, why'd you think that? He said, because one of the guys had a pistol. And they were chasing that boy. I thought that was the police. And so that would have been what Cyrus saw too. He doesn't know why these men are chasing him to begin with, why they're yelling at him. And now he sees one of them has a gun. And he's wondering, why are these people chasing me? What are they going to do to me? And he's running. And Devontae Bryant said he didn't have anything in his hand. Lori Carson pulled up too. Remember her? That's her in that BMW. A grandmother. She recognized immediately Cyrus was a child. She said he looked frightened. He looked scared. He said it looked like he needed help. He said he didn't. But they were all very clear. The boy had nothing in his hand. He had a backpack over his left shoulder, which we could see in the video, trying to hold his pants up while he ran from these men. But he had nothing in his hand. What does 130 yards look like? Well, it looks like this. It's a long distance. It's too damn long. It's 130 yards too long. 114 pounds, 1 second, $1, 21 grams. Cyrus was shot in his back as he ran away from Rick Chow and Andy Chow. He entered his lower back, just to the right of his backbone. It traveled upwards, you see. It went through his lung, you see. It entered the right ventricle of his heart. It came to rest there. And that trajectory tells us he was trying to get away to the very end, trying to run from danger. He died scared. He died bleeding to death. With Rick Chow's face being the last one he saw. He died surrounded by strangers. He died scared on the side of a road in nowhere America. He died young. He died because of Rick Chow. Shot in the back. Today Rick Chow says, well, guys, I had to do it. I had to kill that boy. I had to chase him down and I just had to shoot him. He says his son yelled gun and he had to shoot. He tells you he was justified in doing it. And he says, well, if you're wondering why I shot and killed a child in the back, it's because of the doctrine of defense of others. That's what he says to you today. And he was dead wrong on May 28, 2023, and he's dead wrong today. Okay. So, what is the law of defense of others? There are 4 elements that the state has to disprove one of them, okay? But these are what would get you a charge and find that you would be justified in killing somebody based on the law of defense of others. If any of these are disproven, any one of them are disproven by the state, then he does not get that legal justification for killing. You understand? If you find any of these to not fit for him, he does not get the defense of others. Number 1, okay? I want to be clear. He fails right off the bat. What is the number 1 element of defense of others? The very first one, that he fails miserably. Rick Chow and Andy Chow both must be without fault for bringing on the difficulty. Y'all remember those questions I asked Andy? And by the way, the other thing y'all get to consider is credibility of witnesses. Y'all seen people lie before. Y'all seen people tell half-truths. Y'all seen people waver before in questions they didn't really want to answer. Y'all seen that before in life. Y'all have a chance to sit back there and talk about whether y'all found Andy to be a credible witness or not. But one thing I asked him is, Andy, Cyrus is still alive if y'all stay in the gas station, right? He said, yeah, you're right. But then they decided to ramp it up. They brought this difficulty on, okay? One of his lawyers said, well, you know, Cyrus would be alive if he didn't have a gun. And I said, you would never have known he had a gun, would you? if you just kept your butt in the shell station, kept doing the work you were doing. Stay behind the cash register. And Rick, stay back in the, what do you call it, your surveillance room back there. Why don't you just stay back there? Why are we running 130 yards off our property? Even after he loses his shoes and his cell phone, why aren't we just stopping on the property? If we need to see which direction he goes in, well, we see him running up that straight road, and we know it's a dead end, and we got all these pictures of him. Now we got his cell phone, we got his shoe, we got all these pictures of him, we got his clothing, cell phone, shoe. Why do we bring on the difficulty when we don't have to? But right off the bat, defense of others fails. Prong number one. A grown man with decades of experience chose to turn suspicion into pursuit and pursuit into gunfire. We fail immediately. But if we were to consider going on, he fails all four of them. Let me just walk you through it just to be clear. But if any one of them fail, he does not get that defense. But number two, Rick Chow must be under the belief or have a good faith belief that Andy Chow was in imminent danger of death or serious bodily injury, harm. We saw that a fall and the after effects of it, it was such a violent fall that it led to those wounds to his shin. He goes face down into the ground with various witnesses said. And then marker AA right there. That would be the laser pointer, the flashlight we heard so much about. But that is an interesting marker because you know what that tells us? A couple things really. It tells us where Cyrus fell and hit the ground. But it also, along with those wounds to his leg, shows us how violent of a fall it was. That would be where he hit the ground, and the only way this works is if his gun comes out of his hoodie, hits the ground so violently it dislodges the flashlight, and that's where it came to rest. Ladies and gentlemen, if you are a 14-year-old boy, and you know you're not supposed to have that gun, and you're being chased by people, and it spills out, the very first thing you're going to do is pick it up and continue running, which is exactly what Cyrus Carmack-Belton did. He was trying to get away. But as you see right there, that would be where he fell. And we know he continued running because his body's found past those two poles. But what is further up towards where his body came to rest? AB right there is that shell casing. That is approximately where Rick Chow stood when he fired the weapon. So even after we see where Cyrus fell, Rick Chow is still advancing towards him, still moving towards where he ultimately came to die. I don't know how you describe being in fear of this boy and being terrified of him, but even after he falls and you supposedly become aware of a gun that spills out of his pocket, you continue to advance towards him. How do you say now that you were in fear of him? And would a reasonably prudent person have done this? Would a reasonably prudent person have even left the shell station? The answer is no. He fails 2, and he fails 3. So finally, Andy Chow must be shown to have had no other probable way to avoid the danger of death or serious bodily injury than to act the way he did. Okay? I don't understand how you can ever say I'm retreating when you were the one chasing somebody, chasing them off your property, chasing them 130 yards down a road that you don't belong on. How do you then say I was retreating? No, you are advancing. You were the one bringing on this difficulty. You started it, and you're the one who continues it. Rick Chow fails all 4 prongs of defense of others, and he fails spectacularly. We only have to prove one. Number 1, he fails right off the bat. I submit to you, he fails all 4. This would be a shot by now. You know, we spent a lot of time. I know it's been boring at times trying to orient you guys with the landscape, but it is important, really, to kind of have a general familiarity with this area we're talking about. But if we're looking at this picture, which is an evidence, y'all seen those poles right there a number of times. That's kind of a good marker. You've seen this drainage ditch right here on the bottom where the backpack was found. That's another good marker. Behind us would be the Shell gas station and Park Lane Road, and forward is just the dead end. This would be approximately where that laser flashlight attachment would be found. And again, that's where reason tells us that Cyrus fell. And the gun apparently hit the ground hard enough to detach the laser flashlight. That's where that was found. A little bit further up again, past where he fell, that means Rick Chow is still advancing past where that boy fell and continues chasing him with his gun. That's where the casing's found, right there, the green area. Behind those trees, there's Bradford Bears right there. That is where, we know from the body camera, that's where Cyrus comes to rest. That's where he dies. I mean, just on the side of the road, nowhere, South Carolina. Shot on the side of the road like a dog. Surrounded by strangers. Mother not there. Grandma not there. Scared and alone. Murder is, in South Carolina, statutorily defined as the killing of another person with malice aforethought. Okay? But what is malice aforethought? The judge is going to define malice for you. This is malice. You see this right here? Y'all see that? Look at it. This is what malice looks like right here. There's hatred, ill will, or hostility. We know how Rick Chow feels about shoplifters. Okay? He has devoted a large amount of space in his store to advertise shoplifters and identify shoplifters. He doesn't like them. Malice is ill will or hostility towards another person. It's the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury under circumstances the law will infer an evil intent. When does malice need to form, and when does it need to exist in the mind of Rick Chow? The judge will tell you it does not, malice aforethought does not require that malice exists for any particular time before the act is committed, but it must exist in the mind of the defendant just before and at the time of the shooting. Okay? Therefore, there must be a combination of the evil intent, the prior intent, i.e. chasing a boy up the road with a gun at your side, and the act, shooting. How can malice be shown? There are two types of ways it can be shown. It can be expressed or it can be inferred. They're not different, but just the way they may be shown. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. Malice can be inferred from conduct showing a total disregard for human life. This is malice right here. Y'all see malice? This is what malice looks like. Shot to the back tells the story better than any witness ever could. The state must prove their case beyond a reasonable doubt. This is the standard of every criminal case from here to Seattle, all across the U.S. The state must prove its case beyond a reasonable doubt. What does that mean? Does it mean beyond all doubt? Does the state have to prove a case that leaves everyone saying, I have no doubt about anything anymore? No. It means that if you have a doubt that is reasonable, whether he's guilty or not, do you have a doubt that he's guilty? If you do, is it reasonable? Is it based on logic? If it is, then you should find him not guilty. That's just the law. That's how it's always been. But if your doubt as to whether or not he did what he did is not reasonable, or your doubt is not really logical, you must find him guilty. Does that mean you have to be 100% certain about everything regarding this case? It does not. The judge will tell you there are very few things in this world we know with absolute certainty, and in criminal cases the law does not require proof that overcomes every possible doubt. He's going to say, if based on your consideration of evidence you are firmly convinced. I put that in bold because to me it's the best way to understand beyond a reasonable doubt. When you go back there and y'all are talking about issues or what you remember about specifics of the case, just ask yourself, are we firmly convinced? Let's all take a poll. Are we firmly convinced of his guilt? And if everybody raises their hand, then you find him guilty. That is how you determine whether or not there's reasonable doubt or whether there's proof beyond a reasonable doubt. Are we all firmly convinced? Remember those two words. He's going to say it twice when he reads those instructions to you. Firmly convinced. So when y'all get back there and y'all say, what was reasonable doubt again? You say, well, I remember Dale saying firmly convinced. That was what we have to decide. Are we firmly convinced? Cyrus will forever be 14 years old. It'll always be the beginning of summer. Ninth grade in high school, they'll never come. You won't get the chance to catch the eye of a pretty girl. He won't get to feel rejection either. He won't be at the prom with his classmates. He won't have a chance to be cool or to take that winning shot. He won't have the opportunity to be a loser. He'll never get the chance to figure things out. He'll never feel his grandmother's kiss on his forehead. He won't get to drink that beer when he turns 21. He'll never catch snowflakes on his tongue again. He won't get to feel the sun on his face that first warm day of spring. He'll never get to find his way in this world that can be so cruel, but so beautiful. He won't be like this 14-year-old boy and look in the mirror and see these wrinkles and this gray hair that just kind of came out of nowhere and be able to trace them and think back of the memories and the experiences behind them. He'll forever be 14, alone and scared. running up that road, trying to get somewhere safe, but never making it. The solicitor, Stephanie, and Weston and I, we walked that stretch of road on Spring Tree a dozen times or more. The air, it just feels heavier. The energy it's off. The tragedy of a life cut short is just burned into the surroundings. I can't explain it. And the question isn't why does a 14-year-old have a gun? It's why is an armed 57-year-old man chasing a boy 130 yards, knowing how scared he is, and then shooting him in the back. You know this is wrong. You know it's wrong. You're dead wrong about that water. Mr. Chow, Rick Chow, is dead wrong about this. 14, 130 yards, $1, 1 second, 21 grams. In the early 1900s, there was a doctor. He thought he could measure the weight of a human soul. He thought it was possible to determine the physical weight of a human soul. He measured 6 patients just before and then right after death. And in one of them, he found something interesting. One of the patients, he determined there was a difference of 21 grams. And so he determined, based on that experience, that the human soul weighed 21 grams. 1 out of 6, very small sample size, and it wasn't well documented, but still, it became a popular concept that the human soul weighs 21 grams. We know that's silly today in 2026. What does our spirit weigh? Does it weigh 21 grams? No, we know that's silly. Just like we know a human life, there's no value you can put on it. It's worth way more than silver and gold. It's worth way more than this. You know it. Ladies and gentlemen, you have a decision to make. I thank you for your time and attention this last week and then today. I thank you. There is only one verdict here that speaks the truth. There is only one verdict that addresses what this man did and what this man took away. One verdict. That verdict is guilty. That's what I ask you to do. Find Rick Chow guilty of unjustly taking Cyrus Carmack-Belton's life. Find him guilty. That is the only verdict that speaks the truth and speaks to the evidence in this case. Thank you.
That's right.
All right, we'll take about a 10-minute break. The technology and stuff sorted out. All right, ladies and gentlemen, we're going to take a short break. We'll be right back with you. About 10 minutes. We're going to discuss the case or anything of that nature. We'll see you shortly. All right, we'll be at ease for about 10 minutes.
All right, so the court is taking a 10-minute recess after hearing closing arguments from the state. How did you guys feel about the closing arguments from the state? It seemed like the prosecutor was doing his best to humanize Cyrus, but it was more of a self-reflection. And I feel like sometimes prosecutors just don't take enough time with the family to get to know much about the victim before they end up in opening statements or closing arguments. But in this case, there's so much to consider, and I didn't really hear anything about what Cyrus enjoys doing, or the things that he would actually miss out on. I mean, he talked about peaches. Did Cyrus like peaches? I don't know. Anyways, so I just feel like prosecutors could take more time getting to know these cases and their victims before they end up in this courtroom setting. And I think if they knew more about the victim, that would land with the jury and help to humanize Cyrus even more. Probably what this guy grew up doing at 14 and what Cyrus is going to grow up doing at 14 are not similar things. Probably very different, and very different time, very different area. So all things to consider. Now, he talked a lot about the 4 elements of the law of defense of others. And there are 4 elements that must all be adhered, or must all be met as far as criteria. And if one of those things is not met, then they cannot use that defense. And that's been their defense all along. Now, what a lot of people watching this trial may not know is that there was a stand your ground hearing before this trial. And the judge had to decide, does this case meet the criteria for stand your ground defense? And they ruled no on that and proceeded the case to trial. And here we are. So, the defense all along, you're going to hear a lot, I suspect, in the closing arguments from the prosecution about Cyrus having a gun and how the Chows were deathly afraid and feared imminent danger. But the first part of this is must be without fault for bringing on the difficulty. And they showed us in that video the exact path and how far it was that he chased him, 130 yards. And in Andy Chow's testimony on Friday, the prosecutor asked him, how far were you going to chase him? And where were you going? I mean, what was the point in continuing to chase him? And Andy Chow said that Cyrus fell twice, or he went down twice. So we know he fell once and got back up. And they did flash that injury a minute ago. I feel like that was an accident. Court TV usually will not show bodies and things of that nature. So that was an autopsy photo that we saw there, kind of flashed by the screen, but it showed the injuries on his legs from falling, which were pretty bad. So he fell hard, and I don't see why, when he got back up, the Chows would continue to chase him over $1 a bottle, a $1 bottle of water that he did not steal. Lots to consider in this case, but I think the beginning of the opening statements, were spot on. What is the value of a life? And I have a son who's 14 years old, so I could not imagine losing him, especially, like this. So, anyways, hoping for justice for Cyrus's family, and, nobody wins here. So, the Chows, I've seen a lot of people talking about, what they're going to do to the gas station. This family no longer owns this gas station. It has been sold. They no longer own or operate it. So whoever does, I don't think is connected to this family. Anyways, we have about 4 minutes left, and then we're going to go back into the courtroom for the defense's closing arguments. And we'll just see what what continues in this. I can already tell you what the defense is going to say. They're going to say he had a gun, he had no money, he was in the gas station, he was looking at these bottles of water. Yeah, he took them out. Yeah, he put them back. But they did not know that. They chase after him, and that's not against the law. And as A lot of the witnesses stated, no, it's not against the law, but it's not good common sense, and this is the reason why. Anyways, back into the courtroom we go. We're just going to hang out, wait on them to start back up. We've got about 4 minutes and 7 seconds, but they're never on time, so stay with us.
Remain seated. Whoa, wait on the defendant. Yeah, go downstairs.
Drew, see you, Your Honor.
Thanks, sir. Ready?
Yes. Can I please report?
Yes, sir.
Solicitor. I remember growing up and watching shows with my father. And I'm old enough to date myself a little bit that we would actually listen to radio shows. And one of the radio shows that we would listen to quite often is a guy named Paul Harvey. And what he would do is he would tell stories. And in telling stories, what he would do is tell a story that he thought that everybody actually knew. He would tell a story and he would give details of a story that he thought that everybody actually knew already. And he would tell it, and he would tell it in his interesting way, but what he would do is intentionally leave out parts of the story so that people would be a little confused, because they'd heard the part of the story that they thought that they knew, but he would leave parts out. And then he would take this huge pause after he was done and everybody think it was over, and then he would say this famous line. He would say, "And now it's time for the rest of the story." And then he would spend the rest of the show telling the listener the rest of the story that they did not know. He would do this because he understood people. He understood that we are a generation of people who simply listen to headlines, listen to flashy things, and don't hear the rest of the story. He understood that if he could tell just small parts of the story in the way that people thought that they understood them and didn't hear the rest of the story, then they would believe things one certain way. And the way that he did it was fascinating. It was interesting. People started to understand that that's the way we have to start listening. Because if we only hear part of the story, then we can never get to the truth. And so as we sit here and get ready for our closing argument, all we're going to do now is tell you the rest of the story. I will tell you wholeheartedly, and this might come across as a shock, I agree with some of the stuff that the state of South Carolina said. When they got done with their closing argument, folks next to me said, "Do you want to take that dollar down?" And I said, "No." Because let me tell you with unabashed honesty, they are 1,000% right about the following statement. If Rick Chow executed a human being over a $1 bottle of water, enjoy hell. Let's make that clear. If Rick Chow shot a man in the back stealing $1 bottle of water from his store, you do what you will. Because there's nothing to justify this back and forth. Was he right? Was he wrong? It doesn't matter. Taking a human life over a bottle of water is absolutely ridiculous. It's wrong under any way that you could possibly look at it. And that's why the state has gone out of their way to put this $1 bottle of water up, to put this picture up, because they want you to believe that this is what this case is about. The rest of the story. It has nothing to do with this water. It doesn't. Because if that was what it was about, this wouldn't be a complicated case. As we sit in front of you, the things that we have to talk about is we have to break down everything that we have watched in this case. And we need to break down what the state of South Carolina has presented to you. And as we break it down, we can break it down inside of 3 classifications of what they've put on the scene. They put on what they call eyewitnesses. They put on investigators. And they put on experts. You remember? Those are the 3 things that they have given us. So first, let's talk about the eyewitnesses. And the reason I want to talk about the eyewitnesses first is, remember, and I wrote down a quote that the state said, "Cameras don't lie. For 17 seconds, you could have played the camera. For 17 minutes, you could have played these cameras." If you remember, these witnesses got on the stand, they sat in front of you, and I asked them questions. They looked directly at you. They were talking about what they remembered. They were talking about their memories and how important that is. And then I started asking them questions from right there. You remember? I said, "No, I'm not trying to be rude, but I remember you talking to 911. Do you remember that?" "Yeah." "And you said something different to the 911 tape that you're saying right here today." I asked another person, isn't it true that we don't interview witnesses together because they can get their stories together and their brains could get something that didn't really happen? Yeah. And that's on video, correct? Cameras don't lie. And they called 911, and in the 911 call, they said they didn't see anything, correct? Cameras don't lie. But don't you remember, and I asked one of the witnesses, isn't it true that you told them something, and they said that was completely impossible? Well, yeah. And then they've met with you, they've talked to you, they've interviewed you, and put you on the stand, and you told something different. Cameras don't lie. So why are we sitting here and not watching those videos? Why didn't the state give you the 911 calls? Why didn't they give you the videos? Why didn't they give you the information? If cameras don't lie. The rest of the story. I talked to one of the investigators and officers as he took the stand. Remember, we asked him, what is important as an investigator? It's important to get the facts. It's important to get the information. It's important to get the evidence as close to the incident as possible. So we can do what? Remember the question I asked him? So we can give all the information to the jury. The rest of the story. Because what we don't want to do is subject and put our emotions in there, our personal beliefs, our subjective decisions. That's what's happened. The rest of the story. But for some reason, the state of South Carolina doesn't want to give it to you. One of the witnesses took the stand, if you remember correctly. Detective English took the stand. You remember? One of the first ones they put on. And they put the videos up on all of these screens, all this technology that the state of South Carolina has. And they put up all of it. And one of the clips they put up was of Rick Chow's statement. You remember? And they played it, and it said, my son saw, I didn't initially see my son that he had a gun, so when I looked at his hand, and then what did that officer do? He just walked away. We knew there was a second part of the video. Cameras don't lie. It would have taken how long was the quote? 17 seconds to play it. Cameras don't lie. And what was the next question from the state of South Carolina? Isn't it true he didn't tell you on that scene blank? Cameras don't lie. So we literally had to make sure you knew the rest of the story. And what did we do to tell you the rest of the story? We brought that other officer on to tell the rest of the story. And you remember, it went right together. The rest of that statement. My son saw, I didn't see it initially. My son alerted me that he had a gun. So when I'm going to go talk to his son, that's when he walked away. And then the statement kept going. Look at his hand. He actually had a handgun in his hand. The rest of the story. He got up running, then my son yelled, he's got a gun. So when I watched, there was a gun in his hand. That would be some important information for the state of South Carolina to tell you. But they need it to be about $1. They need to scare you. They need to make you afraid. They made you think the great Rick Chow, this evil human being over here, killed a man over $1. And that is disgusting. That is awful. That is abhorrent. But that's not what happened. The rest of the story. We don't want to tell you the rest of the story because if you hear it, then you get to make an intelligent decision, and we don't want you to make an intelligent decision. We don't want you to hear the 911 calls. We don't want you to watch the videos. We don't want you to hear what Rick said at that moment, at that time, without a lawyer, without anyone telling him what to say or do. We had to play those for you. The rest of the story. And as we get in there and we listen to this and we go through all of this information, it becomes incredibly important. We then had investigators take the stand. You remember the questions I asked of the investigators and why they were so important. The state of South Carolina, for you to make a decision, has come in front of you and said, put witnesses on the stand. Guns aren't that bad. 14-year-old kids have guns all the time. And they had witnesses literally with their hands on the Bible looking at you, talking about, guns are prevalent. It's not that big of a deal. That was the testimony. I didn't make that up. That was the testimony that they submitted. Do I think they believe any part of that? Not a line of that. But they have emotion. They're upset. And they want you to believe it's about a bottle of water. It's not. The rest of the story. And then there was an expert who took the stand. You remember? I asked her a very directly question. I had her sit right here. She stood in front of you. as if she was Rick Chow. And I showed her what we said Mr. Belton could have been doing. And what did she say? Yeah, that's possible. The rest of the story. She described the bullet path, back to front, right to left, slightly upward. The rest of the story. We got to avoid all of that because that changes our narrative. So now we go into what they did present. Now let's talk about the part of the case that we're all wondering about, the thing that everybody's there, and if it's in your gut, it should be in everybody's gut. And they spent their entire case. Their case was a day and a half, and most of it they spent it on one part. The chase. The chase. The chase. They shouldn't have done it. They shouldn't have done it. They shouldn't have done it. You remember one of the witnesses, the investigator, got on the stand, and I had to ask him the question, is there anything illegal about that? No, sir. But that's what they're talking about. Well, common sense. We don't want you to do it. But it's not illegal. That's an important distinction to know. This is a store. The testimony was they've owned it for 11 years. Margins are small. You've seen the wall of shame. People have shoplifted. People have stolen. Chased them. I've been stolen from. I chased the people to Georgia, flat out. It's their property. They're emotional about it. And that's why he ran after it. The question isn't, do you think it's right? The question is it legal? And then you go to the second part of it, is it legal? If it was illegal, don't you remember Andy Chow sat up there on the stand? And Mr. Scott got right in his face, and he was yelling at him, and he was going angry with him, and he was saying everything to him. But the one thing he didn't say to him is, and you have been charged with following this young man out of the store. And you are criminally liable for following this young man out of the store. Because he's not. He's not liable. He's not criminally liable. He has not been charged. And he did not do anything wrong. But when you Monday morning quarterback and come back and look at the situation and say, well, why? You know what? They could have done this. They could have done this. They could have done this. Because that's what the state's case is. Think about it. How many times did you hear throughout the course of this trial the great state of South Carolina say the following sentence? They could have done this. 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 They don't have evidence to offer, but they have fear, passion, emotion, and they want to get that out of you. They want that fear, passion, and emotion, and for you to ignore the law. We do not get to take the law the way that we want it to be. We take the law the way that it is. Let me say that again. We don't get to take the way that we want it to be. The solicitor can't say, well, I want it to be illegal for a shopkeeper to go out of the store. Shopkeepers should not be able to follow somebody. That's what I want. Andy, that's what I want. That's not the law. And then there's one last part that he, for some reason, has ignored. Let's say one of you, just one of you for argument's sake, are sitting back there and you say, you know what? I think they are at fault in bringing on the difficulty. It may not be legal. It may not be illegal, but I just don't like the fact that they follow him for 130 yards. I do not like the 130 yards. I do not like the 130 yards. Well, the judge is going to charge you on something on the law. And it's called withdrawal. Let me explain that concept to you. Let's say one of you start a fight. Let's say I start a fight with Mr. Scott. And let's say I go up to him and I say, I'm going to get you. I'm going to take you down. I'm going to hurt you. And I start the fight and I come at him. And I'm about to hurt him. And then all of a sudden I said, you know what? This is stupid. I don't want to do this anymore. And I turn around and I'm like, I'm over this. And Mr. Scott brings a knife and comes out. Well, according to their theory, I got to let him stab me. According to their theory, I got to let him hurt me, even though that I have withdrawn. Well, that is the law of withdrawal. If an individual says, if they withdraw by words or actions, their right to self-defense is back on the line. The rest of the story. And don't take my word for it. The judge is going to instruct you on the law, and that's one of the things he's going to talk about. So when we talk about the chase, when we talk about why did they run out of the store, when we talk about they shouldn't have gone out of the store, as I told you, you legally have a right. The officer, their own witnesses told you, they legally have a right. This officer with 25 years of experience, dealt with shoplifting, dealt with this, and says, we prefer you not, common sense. But then there's a last part of that. that wasn't on their little pretty board the right to withdraw. When Andy Chow testified, when he told you what happened, he said, I was following him. I was running after him. He fell. When he got up, he had this gun, and then I went this way. And as his hands were up, remember I asked him directly, the gun was still pointed at you? Yes, sir. You were looking directly at the barrel? Yes, sir. And then what did you hear? I said to my dad, he's got a gun. He's got a gun. And then what did he say his dad said? Drop it. Stop. Drop it. No. There's nothing more withdrawal than that. When he's yelling, stop it. Drop. No. That's a withdrawal. That's saying, look, man, you got it. You got the gun. I'm good. They love to say that everything could have stopped. He could have put the gun down. But we have to ignore that because that's not part of their story. We cannot tell that part of the story because it's not necessary. And when we tell this story, you might look at me and say, oh, Mr. Kent, that's some creative lawyering. No. That's why we played the 911 tape. And in the 911 tape you heard. That's why we played Andy Chow's interviews. Didn't hide it. What do you say? Takes only 17 seconds. What was the other quote? Better than any eyewitness ever could would have been a video. That's what the tape said. Better than any eyewitness ever could. So why wouldn't you play him? Because it would have been better than any eyewitness ever could. Now let's talk about the fact, we talked about the story and the things that happen inside of the store. And there might be questions, why did you guys keep bringing these things up? If you remember, I had the officer on the stand. Great officer, great investigator, great person. But I had him on the stand, and I was talking about firearms and 14-year-olds, and he went back and forth because I don't think they wanted to admit that this is a problem. But the thing that was the most important is I asked him about suspicious behavior. Did something look weird to you when you went back? And he didn't want to admit it. But use your own common sense on that. I asked him the direct question, looking back through your investigation, as you have gone through and looked at the full file and looked at everything now, do you find it weird, odd, suspicious that a young man would go into a gas station without any money, with an empty book bag, bullet in the chamber, and then was looking like he was taking stuff off of the counter? I don't find that suspicious. I find that answer suspicious. The reason we brought this up is not to suggest I don't know what Cyrus was doing. I don't. But use your common sense and ask yourself, that does seem strange. And the reason we bring that up is that would explain why Andy, who was sitting at the front counter, looking back, is watching this and going, he's acting strange. He's acting weird. He's putting water back up, water back up, water back up. It looked weird to me. And then he came up to the counter with his hands in his hoodie, and there looked to be something heavy in there. I didn't know what it was, and so I asked him, and he did this, and it looked like there was something heavy in there. It was the gun! Did Andy know it was a gun? Absolutely not. But you can understand why Andy would have said there's something strange going on. His behavior, something in the pocket, going weird with the water, that's what was strange. So that is to explain why Andy made the unilateral decision that there was something strange going on here. And then Andy made the decision to follow him out of the store, chase him, run after him, whatever you want to call it, but he made that decision based upon a reasonable belief of what anybody would have thought something strange here. I asked the officer, again, about the suspicious behavior. That 24 hours, less than 24 hours before he came into the store, he posted this on his social media. Do you remember? I asked him about it. And not only was it this was a clip from a video in which he was pointing a gun at a screen with a laser and a flashing light on his Instagram story. You put all that together, you can explain that someone's behavior would have been a little strange. And he would have had that firearm with the light on it. It makes sense. And so that explains why Andy, and don't forget, when the officer was talking and asking questions and he went back to the back to look at that video surveillance that they keep talking about. Do you remember how many times? He's like, I had to look at it 2-3 times. I had to zoom in on it. He had the technology to see what was taken. Andy had one time. And from his vantage point, something was going on. And so he followed him out the store. He ran after the store, whatever you want to call it. The rest of the story. And then Andy testified that he threw stuff out of his pocket. You remember Mr. Scott said, you did not testify to that. I had to show 4 different times where Andy said he was throwing something out of his pockets. 4. And so he went after him. He followed him. He chased him. He's going after him the entire way. And they're right. He fell. He fell hard. And now they're saying, well, he would have naturally picked up his gun. That's why this is important. He's running. Let's put it this way. Let's try 2. 1, he's running and it's in his pouch. He falls. The light goes off, but the gun stays in the pouch, I guess. Or the gun comes out, I guess. I don't know. But he picks it up. And that's what they just testified to. He picked it up. The judge is going to tell you something else about defense of others. You have the right to act on appearances. And you have the right to be wrong. He's going to tell you that. They've just told you. He was running, he fell down, and he picked up a firearm. All this stuff, all this back and forth, he 100% from the state's mouth, he picked up that firearm. You have a right to be wrong. You have a right to act on appearances. And that's what the judge is going to tell you the law is. And that's from the state. I want you to think about that again. Gets up. Medical examiner. Shot. Back. Angle. Pointed. Right to act on appearances. Rest of the story. Or take it another situation. What makes sense? Maybe the light's on the fire. And then as he's running, when he falls, that's when it comes off. We don't know. Because the burden of proof is on the state to prove what happened in that situation. And they've just admitted the one thing we know for a fact is he picked up the firearm. That's from them, not from me. That was their admission. And then as he picks up the firearm, then we have to go with Andy's testimony. And he's right. If you don't believe what Andy says, if you think Andy is 100% a liar, you can stop right now. Andy's lying. He made it up. This is completely not true. The gun was never pointed at him. He never saw this silver barrel that he only would have seen after he saw Discovery. He never saw it. And then let's take that one step further. Not only that you must believe that he is a liar, you must believe that Rick Chow is the most creative, smartest person in the history of the world. He is clairvoyant, if you will. Let's give him an Oscar. Was able to decide, you know what, I want to kill this boy. I need to figure out when he's going to come into the store, when he's going to have a gun, when it's going to be in his pouch. I need to make sure that Andy sees it. And then I need to make sure Andy follows him for the direction. So I need to make sure Andy calls 911 and says exactly what I want him to say. I need to make sure Andy says the exact thing that I'm going to say at the exact time. Because that's what it would be necessary to believe the state of South Carolina's case today. That Rick Chow set all this up in motion to execute a shoplifter. The people he decides, needs, has to help him make a living. It doesn't make any sense. And if we take this one step further from the state's theory, Rick Chow is so pissed off, so damn angry about this shoplifter, hates him so much that he executes him. Why not shoot him when he gets out of the store? Gun's already on his hip. Why not walk out of the store? Shoplifter, $1, he stole, shot. Shoplifter, 10 yards, shot. Shoplifter, 20 yards, shot. 30, 40, 50, 60, 70, 80, 90, 100, 110. Why wait 130? Unless something changed. What changed was somebody pulling a gun and pointing it directly at his son. That's what changed. If he wanted to execute Cyrus, he could have done it right outside of that store. But we have to ignore that because that would be part of the rest of the story. Use your common sense and listen to the evidence, but listen to the witnesses and listen to what they have told you. Murder, as the state has told you, is the intentional killing of another human being with malice aforethought, without self-defense. We have just showed you self-defense and defense of others. The state has melded a little bit of those theories together, but you need to make sure that you understand. One, without fault and bringing on the difficulty. Again, I've explained to you that you have a legal right to follow somebody. Whether they like what the law is, that's what it is. And as you're going through that, then you have to talk about imminent danger. And this is from the eyes of Andy. And they're trying to mix the two of the things together, but it's under the eyes of Andy at this point. As Andy, does he have a fear of imminent danger? Was a gun pointed at Andy? Would Andy, who had withdrawn from the conflict, you got it, I'm over this? No. Would Andy have had a right to point the firearm and save his own life? Reasonable person. A reasonable person in the same situation, what would they have done? And we can take that two ways if we want to argue the state's theory. Way one, Andy, gun pointed at you. Would he have had a right, as he was saying, remember that knife in the back situation? Andy would have had a right to fire to save his own life. But more importantly, the reasonable person's situation, Rick Chow would have had a right, and did have a right, to save his son. The strongest evidence that was given in entire this case, when the officer got on the stand and I asked him that question, and I said, have you ever fired your firearm? No. Have you had a firearm pointed at you? Yes. I didn't fire. What if someone was pointed at your loved one? Yeah. I asked that same officer the situation when officers are chasing somebody and you chase them incorrectly. Remember we asked them that question. You chase somebody incorrectly, what happens? We chase them incorrectly, it does happen. And what would happen if that individual pointed a firearm at you? Remember the example he gave? If someone pointed a firearm as I'm chasing them incorrectly, well, I would tell, and they turned around and pointed a firearm at me, I would tell them, stop, drop it. And if they did not drop it, I would fire. It sounds eerily familiar to this case. And that's some of the rest of the story that the state of South Carolina, for some reason, has chosen not to tell us today. And then we go, duty to retreat, or can you retreat? As a person is pointing a firearm at you and you're pulling backwards and someone is saying, stop, no, don't. That's what duty to retreat is. No one turns and runs. The judge is going to tell you, as I mentioned, if we're talking about self-defense, and I've said it several times, you have a right to act on appearances, and you have a right to be wrong. So as we sit here, and we're in Rick Chow's position, we're wondering what Rick Chow is doing. As we've heard this testimony, Rick Chow sees a gun pointed at his son. His son says, as you heard, I was afraid, I was terrified. He's got a gun, he's got a gun. So Rick Chow in that situation stands in the place of his son. This case is not about a dollar. This case is not about a shoplifter. This case is about a father who sees a gun pointed at his son and had to make a decision. I hate it. I do. I hate that a young man lost his life. I disagree with the state's theory on it's not that big of a deal that kids are going around with guns. I hate it. It is a problem. And it is a problem in this case. I hate that we have sat here and tried to make this about something that's not. I've listened to the state of South Carolina's opening statement talk about Cyrus's age, his future, and I understand all of that. I do. The one thing that does not know Cyrus's age is that gun. The gun doesn't know how old it is. And when a gun is pointed at somebody, you have an option. As we sit here, and talk about this case and how important the details are. That if you step back and look at something one way, it's completely different. And as you get closer and you look at it more and you look at all of the details, you'll never see it differently again. And so what I'm asking you to do is focus on the details. I wear this suit all the time in trials. People say, oh, you always dress so flashy, but you're not flashy today. I wear this suit all the time because it reminds me that details are the most important thing that can happen. It actually has my name and the pinstripes in it, because when you look at it, after realizing it's not just a pinstripe suit, it actually has my name just right down the middle. And I look at it and it reminds me in cases that if you don't take your step back and look at things in full detail, you will miss it, like the state of South Carolina has, and they want you to miss it. We have to focus on important matters. We have to see the full story. You have to ask yourself the question, why don't they want me to know the full story? And then finally, for the state's case to make any sense whatsoever, we have to go back to our withdrawal situation. For the state's case to make any sense whatsoever, you must be comfortable with their theory in that Andy Chow is in the store. Andy Chow runs out of that store. Andy Chow runs out of that store after Cyrus. And as he's running out after the person he thinks is shoplifted on, Cyrus still points the fire. Andy still has his hands up. His dad is still watching, and his dad says, no, I'm not going to do anything. And Cyrus shoots and kills his son. The state wants us to believe that that's legal, and that's okay. That storekeepers should let people take stuff out of their store, and if you follow them and you get killed, it's okay. It's not. Now, you know the rest of the story.
Anything in reply to the state?
Yes, Your Honor, of course, the notice is fine. Move a couple things around.
Yes, sir.
Please, go Chairman.
Yes, sir.
Counsel. Mr. Kent spoke to you guys, ladies and gentlemen of the jury, for a moment or two. And he talked about Paul Harvey and the rest of the story. Sounds a lot to me like this was the rest of Mr. Kent's story. Because many of the things that he said were things that he said, but the actual eyewitnesses never said. It reminds me of when I was a kid, a couple of years maybe before Mr. Kent, but a whole lot of years after Mr. McCullough and Mr. Swirling. We used to, as kids, go down to Augusta, Georgia. My grandmother was from a small town called Trenton, South Carolina. It's in Edgefield County. And way before I was born, probably when I was still a twinkle in my parents' eye, she moved down there because there were just better opportunities to work. And so as I'm growing up in the early 70s, early 80s, my folks would drop me and my brother off down there, and we'd hang out with my grandmother for a week. And back then, when you went to your grandmother's house, you couldn't stay inside and play video games all day because they didn't have them. So we had to go outside. We had to find ways to busy ourselves. We had to do things outside so we didn't break anything inside and get in trouble. So what we'd end up doing is my brother and I would go outside and we'd start throwing the football around for a little while. We'd toss the baseball around for a little while. Then we would start running around her house because my brother was older, so I'd try to catch him. So we'd try to run around and see if I got any faster than he. At some point in time after lunch, we would make our way to this makeshift barber shop that my grandfather had built on the side of the house. And we'd sit down and we'd listen to the old man playing checkers, trying to pick up on some words we probably shouldn't have been hearing. We'd hear him slapping the checkers on the board saying, "King me," and all that kind of stuff. And we'd be learning some old man stories as kids. It was fun. We'd sneak into a little side of the barber shop and try to get his red man shoe. And the joke was we'd try to put a little piece in our mouth and try to hold it in there as long as you could before it burned a hole in your mouth. Or we try to hold it in there and try to see who could hold it the longest before you started gagging. This mischievous stuff that kids do. That's what we did. But at the end of the day, every evening, my brother and I would end up on the front porch. And my grandmother had a set of rocking chairs out there. And we would sit in those rocking chairs and start playing what I call rocking chair games. The first game, we'd sit down and then we'd try to see who could rock the fastest. I'm sure some of y'all have done this. Then we try to see who could rock the fastest and the farthest with your legs in the air. It's good ab work if you ever need to do it. We're trying to go back and forth and see how fast you could go with your legs in the air. And inevitably, the last thing that my brother Chris and I would do, we'd sit down and we'd rock the chair as far back as you could go without it falling over. And we'd do that. And we did that over and over and over. One evening, my grandmother came outside and she saw us standing those rocking chairs up on edge. And we knew we were in trouble. Again, this is the 70s, early 80s. This is the day of knockouts, not timeouts. We knew we were about to get in trouble. But my grandmother said something to me that stuck with me and it still rings in my head today. She said, the funny thing about rocking chairs is that they'll keep you busy, but in the end, they don't get you anywhere. The funny thing about rocking chairs is that they keep you busy, but in the end, they don't get you anywhere. Ladies and gentlemen of the jury, Mr. Kent, Mr. Swirler, Mr. McCullough, and that team over there has kept you busy with all of this stuff. But at the end of the day, the question still remains, what is the value of a human life? They have kept you busy with these insinuations that Cyrus was some young thug, some thug in training, running around Columbia, their words, with a loaded pistol, an empty backpack, and no money. Their words. They have kept you busy with this insinuation that this case has to be about and is only about, and is mostly about, a 14-year-old carrying a gun. We keep talking about why do 14-year-olds have guns? Why do children carry guns? And folks, let's be abundantly clear. Cyrus should not have had a gun. Period. No question. Nobody at the state stable has suggested that he should have. But let's put that aside for a second as we talk about what this case is really about, because he shouldn't have had a gun. No question. Question, are we still having this conversation if Cyrus is 24 years old, if he's 20 years old, if he's 34 years old, 44 years old? Are we having this conversation? Somebody wrongfully accused of stealing, chased out of the store after they tried to de-escalate everything that they could, running, falling down, running out of your chute, tripping, dropping phones, running farther, falling, busting your shin, gun spills out, you're still running. And according to the testimony that you heard from this chair, grown man, Andy Chow, state championship swimmer, 185 pounds, 200 pounds, about 85 pounds more than Cyrus, was right on top of him when he fell. And Dad was close by, in arm's distance. That's what the testimony was, not this, all this stuff. He was right on top of him. Question, as you listen to the elements of self-defense, not bringing on the difficulty, who would have had a claim of self-defense in this case? Cyrus? Being chased by two men, armed with a gun, on top of you after you've run 130 yards? Folks, I submit to you, as I'm walking from that tip back here, you get to the end of this corridor, that's 20 yards, 19 yards. Times 5 plus 30 more yards. That's how far he was chased. So who would have had a self-defense claim? So I'm suggesting to you that they keep insinuating these things, saying these things, because they don't want you to think about it. Again, I mentioned to you this to you multiple times. When you parked your cars, you didn't leave your common sense in the parking lot. Take it with you. Think about these things. Don't let them sway you with all of this mess and all this other stuff that takes us off of what the real issue in this case is. Don't let them do it. The defense kept weaving this narrative, again, that Cyrus is some young thug walking around the streets of Columbia, again with a loaded pistol, no money, and an empty backpack. I submit to you that, folks, if Cyrus was this thug that they keep telling you that he was, by showing you pictures and trying to get you thinking in that direction, we never would have gotten 130 yards down the road. He would have held court right at 7441 Park Lane Road. Cyrus would have been the judge, the jury, and the presenter of the sentence right there in that spot, if he was the thug that table wants you to believe that he was. But instead, what were his actions? Folks, he ran. He ran like a child. He ran from the adult. Let's think about who acted like the thug, the gangster. The person who chased him down the street, or the person who ran while he had a gun hidden. He ran out of his chute. How do we know that to be true? Because we see it on camera. Shoe flies up in the air, and he keeps running. Doesn't stop. Turn around. Oh, I dropped my shoe. Let me get that, because I'm going to get in trouble if I go home with one shoe. He didn't do that. How afraid do you have to be to run out of your shoe and not turn around to pick it up? Ponder on that for a minute. He ran further. Phones fell out. They keep coming to you with this mess that, oh, he threw his cell phones out. What sense does that make? Did you leave your common sense in the parking lot, or did you bring it with you? How afraid do you have to be to drop 2 cell phones and keep running? Again, let's be very logical about this for a minute. 2 cell phones. We know how expensive they are. One cell phone belongs to you, and the other belongs to your mother. Do you mean to tell me that you are going to go home that day with one shoe and tell your mother, Mama, I lost my cell phone and yours too, and I didn't turn around to get it? You want that smoke? Do you really want to get what you would get if you lost 2 cell phones from your mother? But you know why he didn't turn around? Because he was scared. Because that man, armed with a .45 caliber pistol, and his son were chasing him for no reason down a road in South Carolina. Chasing him. Didn't turn around. Kept running further. Fell again. Hard. Dropped the backpack. And by the way, since they want to keep saying it was empty, it actually had some personal effects in it. There was an address in the backpack. Really? Fell. Dropped the backpack. Didn't stop and say, oh, stop guys. Let me go get my backpack. Let me go get the phones. Let me go get the shoe. Kept running away from them. Is that a thug? That's a kid who was scared of two grown men, running as fast as he could, as far as he could, trying to get home. But they wouldn't allow it. They would not. For some reason, they could not allow it. And then, at some point, as he fell, hit the ground, that gun comes out, that tack light comes out. Now, I'll suggest to you, as Mr. Kent talked, he keeps saying, well, he was picking up the gun and he was pointing the gun, all that kind of stuff. Stop, just stop. Because what we say is not evidence. I told you before, the evidence is what comes from this witness jury. There were 4 eyewitnesses who were not named Chow. Which one of them ever said they saw Cyrus Carmack-Belton point a gun? Which one? Which one? No. 4 of them. 3 different vantage points. Lori Carson, Kennedy Carson, mom and daughter. They told you they watched and they saw a straight line of what happened. Cyrus ran, fell, hit the ground, got up running, and that's when he was shot. Asked multiple times, well, did he turn at them? Did he point at them? Did he do anything? No. We never saw anything in Cyrus's hands. 2 witnesses, mom and daughter, vantage point at the front of the store. Didn't see any of that. Any of that. Devontae Bryant, driving, white Honda, threw on brakes so he wouldn't run over anybody as they ran in front chasing Cyrus. Asked as he rode by, did you see him point anything? Cyrus Carmack-Belton point, stop and point. No, he didn't. He didn't have anything in his hands. The book bag fell. He was flat. He fell hard. His hands were on the ground. He got up trying to run, and that's when he started stumbling again and got shot. Again, trajectory. Here, upwards, to the left, making perfect sense that he's running away. Not pointing. Not pointing. Like the defense wants you to believe. Remember the multiple times they tried to see with Dr. Durso, well, was he doing this and was he snaking and popping and locking? No, none of was ever said. He was running, and when they tried to do that, he said, no, it's more consistent with the shooter being directly behind him. Folks, if he was turned in the direction that they want to believe, his spine would have been severed by that bullet. Common sense. You didn't leave your common sense in the parking lot when you parked today. You brought it with you. That again is why we went through that process. Some of you may think it was painstaking last week to sit you as jurors, because we wanted you to take the facts of this case. Not Paul Harvey, not Steve Harvey, not some other Harvey, but the facts of this case that came from this witness chair. Not some stuff that's speculated or what we can kind of come up here and start trying to come up with about moonwalking backwards and all this kind of stuff. None of that. The evidence that came from this chair. Did you hear that? Another witness. Jasmine Broadwater. Another vantage point. They're running directly to her. Did she say she ever saw a gun in Cyrus's hands? No. Did she ever say she saw Cyrus point? No. Never. Nobody with the last name that's not Chow says that ever happened. And interestingly enough, you saw in the video, after the shooting took place, who was walking around? Rick Chow. The officer had to tell him multiple times, stand still, don't touch evidence. I'm going to charge you with obstruction if you keep messing around there. Move the gun. By the way, he and his family went to the store, came back, had plenty of time to talk about what they were going to say. Plenty. But at the end of the day, when Andy sat up here, there was nobody to protect him from cross-examination. Nobody to protect him. There was conversation about a barrel. Andy says, I saw a silver barrel. Folks, I submit to you, there is a gun lock on here. This is not the condition of the gun. You'll see it on that video. The condition of the gun was this. That's a black barrel. right? So y'all blame me for this one. This is my fault. I will say this, it's my fault. Maybe we should have brought in another expert. Maybe a 10-year-old or a 12-year-old or a 13-year-old who can talk to us about the intricacies of cell phones. My gosh. Maybe they could tell you that if you hit the right click button on an app.
Yes, sir. Sure.
So maybe we should have had an expert to talk about apps on phones and the fact that in 2026, even back in 2023, you did not have to have cash in order to buy stuff. You can pay on the phone. Maybe that should be an expert that we call next time, since they made such a big stink about those things. Folks, Andy was an interesting person on the stand. And I'm sure that it's tough to have to sit in that situation and recall what was said and what wasn't said and what you thought about in those moments. But it was interesting to me that under direct examination, that testimony flowed. It was quick. Everything that he said was perfect. Just came out like water. But then on cross-examination, and y'all get a chance to watch from your vantage point, that's the word of the week, vantage point. Every time he was asked a question under cross-examination that wasn't pleasant, that actually required some type of thought process that may not go exactly how he rehearsed his testimony, eyes. To the point to where he said, well, my counsel said I couldn't. We don't want to know what your counsel told you. But every time a hard question came, his eyes went from here to there. Folks, I was taught a long time ago, when you lie, you got to remember what you said, right? And if you lie about the small things, then you can't be trusted with the big things, to tell the truth about the big things. So think about that for a minute, because when we talked to Andy, there was a back and forth about simple stuff, like through versus dropped, right? Like pulled versus pointed, which again, no witnesses not named Chow ever said the word pointed. Like chase versus follow. Why are we having conversations about chase versus follow when you saw how fast they were going after him? Folks, I may not be the sharpest tool in the shed, but to me, running after, you hear the bus go by, you're missing the bus. You run after the bus. Why? So you can catch the bus and get on and get to school. Or maybe more recently, flying from Columbia to North Dakota. And there's a flight, the first leg takes you to Charlotte, second leg takes you to Minneapolis. You get to Concourse A, your flight takes off in 28 minutes. What you gonna do? You're gonna run to Concourse C to catch the flight. Why? Because you don't want it to leak. You run with the purpose to catch. Folks, I ran after my wife for 2 years, and I caught her. But do you think when I caught her, I said, hey, I want to give you directions about how to get to that dude so he can tell somebody else about something? Come on, folks. When you parked your car, you didn't leave your common sense. They ran to catch. At the end of the day, what happened here is simple, and they don't want to admit it because it hurts. They ran after Cyrus emotionally. They were irritated. They were mad for whatever reason. They ran after him. They caught him. They caught up to him because he fell. They caught up to him because he fell multiple times. They wanted to shake him down and get that bottle of water, and then figure out what to do with the police later. That's why they ran. That's the simple truth. That's the simple truth. That gun spilled out, and then that man made a rash decision. He overreacted. Andy saw the gun. He said gun, and he shot him. There wasn't all this time to back up. No witnesses even say that he even backed up. They said they were advancing the entire time. Folks, don't let the defense rewrite the facts, because the things they talked about didn't happen that way. They didn't happen that way. For over an hour, Andy sat on that stand, and he said a lot of things. He said a lot of things. But did you ever hear the 2 words? I'm sorry. I'm sorry that I wrongfully accused this kid of stealing and chased him down the road. You know why? You didn't hear that? Because he's not. This is about product over people. This is about inventory. This is not about a person's life. Mr. Kent spoke about withdrawal. And he keeps trying to suggest that Andy Chow withdrew by doing this and coming backwards all this way and saying, hey, stop, hey, Dad, you gotta go. Nobody testifies that that happened. He doesn't have the last name of Chow. 4 people who don't know one another, who had to be subpoenaed to come to this court, spoke to you, and they never said that it happened, because it didn't happen. He did not withdraw. They kept going forward. They kept going forward. And ultimately, this gun was never pointed. But folks, I suggest to you, even if it was pointed, he was running in the opposite direction. Opposite direction. That's what the evidence shows by the way he was shot. It was in the opposite direction, trying to get away. I'll say this. It's offensive to hear the defense keep trying to characterize Cyrus as this young thug. But it's equally offensive to then try to characterize Andy Chow as Mr. Rogers. Excuse me, Rick Chow, the defendant in this case, is Mr. Rogers. You know, the man who chased a kid down, shot him in the back. And then they want to say, well, he was trying to help, clean vomit out of his mouth to resuscitate him. Folks, that's offensive. Because the last face that this scared child saw as he ran away was that man peering over him. Peering over him. And none of this happens if they stay their behinds in the store and use that intricate camera system that picked up on every angle. Could see everything from what he wore, the type of shoes that he wore, the direction he went, everything. A couple seconds is all it would have taken, just like it did in the store, to say, hey, you know what, we were wrong. But they didn't do that because they were overcome with something. Maybe it was meanness. Maybe it was malice. Maybe there's some nefarious intent in their heart. A reason for them to chase him and shoot him in the back and end his life. But again, never the 2 words that matter most, and I'm sorry or I made a mistake. However, none of them, because they're not. I talked to you about a poem by Omar Khayyam called The Rubra. And I told you that I would link it all together. the moving finger writes, and having writ moves on, nor all your piety nor wit shall lure it back to cancel half a line, nor all your tears wipe out a word. Folks, that's a poem about time and how you can't erase what's been done. You can't go back and change what's been done. With all your piety, no matter how many degrees you got, how many doctorates you got, when you do something, it's there, it's done. And you can't reverse time. You may try, you may get up here and get on the stand and try to think your way through it and reason your way through it. But at the end of the day, what they did was murder. So in a more literal sense, eventually we're going to be asking that your moving hand come back and write these words. Because Rick Chow is guilty of the murder of 14-year-old Cyrus Carmack-Belton. Now, folks, you're going to have a chance to deliberate in a moment. And as you deliberate, you will apply the facts of this case to the law that the judge is going to give you in a couple of moments. And as you do that, we're asking, I'm asking, Dale Scott is asking, Stephanie Taylor and Weston Lee, for all of us are asking that you return a verdict of guilty in this case. I'm just looking to make sure that I covered everything that Mr. Kent covered. I ask you to think one last thing, and I'm out of your face. We all know there are 50 states in the United States of America. But I think I've learned sitting in this trial that there are actually 51. There's the state of denial. The state of denial is where that man lives because he's denying that what he did was wrong. He's denying that he chased and killed that young child, Cyrus Carmack-Belton, who never pointed a gun at him. The witnesses tell you so. Not his son, who's got every motive, every reason to twist it around in order to protect his father. Denial that you, the jury, believe or will believe that what he did was wrong. Denial that at the end of the day, he believed that a human life was not more than that. Folks, it's for these reasons that the state of South Carolina is asking you to return a verdict of guilty, because Rick Chow is guilty of murdering Cyrus Carmack-Belton. Thank you for your time.
Thanks, Mr.
Take care.
Madam Floor Lady, ladies and gentlemen of the jury, you've heard the evidence and the arguments of both parties. I'm now going to explain the law which you will apply in this case. Well, maybe I'll do that in a moment.
Quiet, there's a building safety.
Now, the charges that I'm going to read to you will not be sent back to the jury room, so it's important that you listen carefully to the instructions. If you have any questions during your deliberation, I can bring you back out and explain the law to you again if you have specific questions about the law. Now, you and I have specific duties to perform, like we discussed from the outset. As the trial judge, it is my responsibility to preside over the trial. It's your responsibility to consider the testimony which has been presented from the witness stand and the exhibits introduced. I have the duty to charge the law applicable in this case. As presiding judge, I am the sole judge of the law, and it is your duty as jurors to accept and apply the law as I now state it to you. If you already have any idea as to what the law is or what the law ought to be, and it does not agree with what I tell you, the law is, you must abandon your idea because you are sworn to accept the law and apply the law exactly as I stated to you. Your duty is to determine the facts. In every case, the jury is the sole and exclusive judge of the facts. A trial judge cannot suggest, state, comment on, or make any statement to a trial jury about the facts in the case. Since you are the sole judge of the facts, you are not to infer from what I have said during the progress of this trial in ruling upon the admissibility of evidence or otherwise, or anything that I say now during the course of this instruction to you, that I have any opinion about the facts in the case. The law does not allow me to have an opinion about the facts. This is a matter solely for you to determine. As jurors, it is your duty to determine the effect, value, and weight of the evidence presented during the trial. The indictment charges the defendant with murder. The fact that the defendant was arrested, charged, and indicted is not evidence and cannot be considered by you as evidence of guilt, nor does it create any presumption or inference of guilt at all. This indictment is simply the formal written instrument which contains the charge made against the defendant. It is the formal document by which this case is brought into this court and gives this court jurisdiction. The defendant has pled not guilty to the indictment, and that plea puts the burden on the state to prove the defendant guilty beyond reasonable doubt. A person charged with committing a criminal offense in South Carolina is never required to prove himself innocent. I charge you that it is a guiding rule of law that the defendant in a criminal trial, no matter how serious the charge, is always presumed innocent of the crime for which the indictment was issued unless guilt is proven by evidence satisfying you of that guilt beyond a reasonable doubt. This presumption of innocence does not end when you begin your deliberations, but it accompanies the defendant throughout the trial until you reach a verdict of guilt based on the evidence satisfying you of that guilt beyond a reasonable doubt. The presumption of innocence is like a robe of righteousness placed about the shoulders of the defendant, which remains with the defendant until it has been stripped from the defendant by evidence satisfying you of the defendant's guilt beyond a reasonable doubt. The presumption of innocence is not mere legal theory. It is not just a legal phrase. It is a real and substantial right to which every defendant is entitled unless you, the jury, are satisfied from the evidence of the defendant's guilt beyond a reasonable doubt. What is reasonable doubt in the law? A reasonable doubt is the kind of doubt that would cause a reasonable person to hesitate to act. The state has the burden of establishing every fact necessary to prove the defendant guilty beyond a reasonable doubt. The law presumes every person charged with a crime to be innocent, and the burden of establishing guilt is placed solely on the state. The defendant is not required to prove his innocence. Some of you may have served as jurors in civil cases where you were told it's only necessary to prove that a fact is more likely true than not true, such as by the greater weight or preponderance of the evidence. Other civil cases use the clear and convincing standard. In those cases, it's necessary to prove that a fact is highly probable. But this is a criminal case, and the state's proof must be more powerful than those burdens of proof. In criminal cases, the state's proof must be beyond a reasonable doubt. Proof beyond reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. There are very few things in this world that we know with absolute certainty. And in criminal cases, the law does not require proof that overcomes every possible doubt. If, based on your consideration of the evidence, you are firmly convinced that the defendant is guilty of the crime charged, you must find the defendant guilty. The defendant is not required to prove his innocence. If, on the other hand, you think there's a real possibility the defendant is not guilty, you must give the defendant the benefit of every reasonable doubt and find him not guilty. Necessarily, during your deliberations, you must determine the credibility of witnesses who have testified. Credibility simply means believability. It is your duty as jurors to analyze and evaluate the evidence and determine which evidence convinces you of its truth. In determining the believability of witnesses who have testified in the case, you may believe one witness over several witnesses or several witnesses over one witness. You may believe part of the testimony of a witness and reject the remaining part of the testimony of that same witness. You may believe the testimony of a witness in its entirety or reject the testimony of the witness in its entirety. You may consider whether any witness has exhibited to you any interest, bias, prejudice, or other motive in the case. You may also consider the appearance and manner of a witness while on the witness stand. There's been evidence presented that witnesses have made prior statements which are not consistent with the witness's present testimony. You may use this evidence to decide whether to believe the witness. You may also use the evidence of the earlier contradictory statements to determine the truth of those statements. It's up to you to decide whether to believe the earlier statements or the testimony given at trial. If a witness is shown to have knowingly testified untruthfully concerning any material matter, you may consider this in determining whether to trust the witness's testimony as to other matters. You may reject all testimony of that witness or give all or part of the testimony the weight you think it deserves. In order to establish criminal liability, criminal intent is required. For example, the mental state required to be proven by the state for a particular crime might be purpose, intent, knowledge, recklessness, or criminal negligence. Criminal intent must be proven by the state beyond a reasonable doubt. Criminal intent is always a matter that must be determined by the jury from the circumstances existing at that time. There is no way to prove intent to a mathematical certainty. There is no way medical science can dissect a person's brain and determine what the person had in mind. So the law says that criminal intent may be inferred from the circumstances showed to have existed. This is how you make a determination of whether or not the element requiring intent was present. It is not necessary to establish intent by direct and positive evidence, but intent may be established by inference in the same way as any other fact, taking into consideration the acts of the parties and all the facts and circumstances of the case. Criminal intent is a mental state of conscious wrongdoing. You must determine what the defendant intended to do based on the circumstances existing at that time. Criminal intent can arise from action or a failure to act. It may arise from negligence, recklessness, or an indifference to duty, or to consequences that are considered by the law to be the equivalent of criminal intent. There are two types of evidence which are generally presented during a trial: direct evidence and circumstantial evidence. Direct evidence directly proves the existence of a fact and does not require deduction. Circumstantial evidence is proof of a chain of facts and circumstances indicating the existence of a fact. Crimes may be proven by circumstantial evidence. The law makes no distinction between the weight or value to be given to either direct or circumstantial evidence. However, to the extent the state relies on circumstantial evidence, the circumstances must be consistent with each other, and when taken together, point conclusively to the guilt of the accused beyond a reasonable doubt. If these circumstances merely portray the defendant's behavior as suspicious, the proof has failed. The state has the burden of proving the defendant guilty beyond reasonable doubt. This burden rests with the state, regardless of whether the state relies on direct evidence, circumstantial evidence, or some combination of the two. As I mentioned to you during the trial, the rules of evidence ordinarily do not permit witnesses to testify to opinions or conclusions. An exception to this rule exists for witnesses we call expert witness. A witness who, by education and experience, has become an expert in some art, science, profession, or calling, may state an opinion as to relevant and material matters in which the witness claims to be an expert, and may also state the reasons for the opinion. You should consider any expert opinion received in evidence in this case, and like any other evidence, give it the weight you think it deserves. If you decide that the opinion of an expert witness is not based on sufficient education and experience, or if you conclude that the reasons given in support of the opinion are not sound, or that the opinion is outweighed by other evidence, you may disregard the opinion entirely. An expert witness's testimony is to be given no greater weight than that of other witnesses simply because the witness is an expert. Further, you're not required to accept an expert's opinion even though it is not contradictory. I instruct and emphasize to you that the fact that the defendant did not testify is not a factor to be considered by you in any way in your deliberation and in your consideration on the question of the guilt or the innocence of the defendant. It must not be considered by you in any manner whatsoever. I repeat, under your oath, you are to draw no conclusion whatsoever from the fact the defendant did not testify. The fact the defendant did not testify should not even be discussed in the jury room. The burden of proof, as I have stated to you, is on the state. The defendant is not required to prove his innocence. The burden of proof remains on the state to prove guilt beyond a reasonable doubt as to the charge against the defendant. The defendant is charged with one count of murder. The state must prove beyond a reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exist for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms, express and inferred, do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when a person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or of any other act of preparation going to show that the deed was within the defendant's mind would be expressed malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would simply be an evidentiary fact to be considered by you along with the other evidence in the case, and you may give it the weight you decide it should receive. The defendant has asserted defense of others as a defense to his prosecution. Under the law of self-defense, the defendant may take another's life in defense of others. The right to intervene to protect another person is subject to the same rights and limitations as the right of self-defense. The defendant may take the life of a person who assaults a friend, relative, or bystander if that friend, relative, or bystander would have had the right of self-defense. Defense of others is a complete defense, and if it is established, you must find the defendant not guilty. The state has the burden of disproving defense of others by proof beyond a reasonable doubt, and the burden is carried by disproving any one of the four elements by proof beyond a reasonable doubt. If you have a reasonable doubt of the defendant's guilt after considering all of the evidence, including the evidence in defense of others, then you must find the defendant not guilty. On the other hand, if you have no reasonable doubt of the defendant's guilt after considering all the evidence, including the evidence in defense of others, then you must find the defendant guilty. The following elements are required to establish self-defense, and in this case, defense of others. First, to show that the person being defended had the right to self-defense, it must first be shown that the person being defended and the defendant were both without fault in bringing on the difficulty. If the conduct of the person defended or the defendant was the type which was reasonably calculated to and did provoke a deadly assault, the person would be at fault in bringing on the difficulty and would not have the right of self-defense. Therefore, the defendant would not have the right to use deadly force in defending that person. One's right to self-defense or defense of others is restored after a withdrawal from the initial difficulty with the victim if that withdrawal is communicated to the victim by word or act. Withdrawal from a conflict must be effectively communicated to the victim by word or act to restore the right to use self-defense or defense of others. An accused who provokes or initiates an assault cannot claim self-defense or defense of others unless the person defended both withdraws from the conflict and communicates his withdrawal by word or act to his adversary. Second, the defense of another person is excusable if the defendant had reasonable grounds to believe and in good faith did believe that the person being defended was in imminent danger of death or serious bodily harm from the victim. In deciding whether the person defended actually was or that the defendant actually believed the person was in imminent danger of death or serious bodily injury, you should consider all the facts and circumstances surrounding the crime, including the physical condition and characteristics of the parties. The defendant does not have to show that the person defended was actually in danger. It is enough if the defendant believed the person was in imminent danger. The defendant has the right to act on appearances even though the defendant's beliefs may have been mistaken. A third element of self-defense requires the defendant to show that under the circumstances as they appeared to the defendant believed the person defended was in danger, and that a reasonably prudent person of ordinary firmness and courage would have had the same belief under the same circumstances. It is for you, the jury, to decide whether the defendant's fear of immediate danger or of death or serious bodily injury to the person defended was reasonable and would have been felt by an ordinary person in the same situation. The defendant does not have to wait until the victim inflicts harm on the person defended. The defendant has the right to act under the law of self-defense of others, to prevent the victim from inflicting harm on the person defended. The final element necessary in order to be entitled to defend another requires that the person defended have had no other probable way to avoid the danger of death or serious bodily injury than to act as the person defended did in this particular instance. Where the person being defended had no duty to retreat, the defendant likewise would have no duty to retreat. The defendant had no duty to retreat if by doing so the danger to the person defended of being killed or suffering serious bodily injury would increase. When considering defense of others, the relative sizes, ages, and weights of the parties may be considered in deciding the apparent or actual need for force in defense of others and the amount of force needed. A person cannot be required to make an exact calculation as to the degree or amount of force which may be needed to avoid death or serious bodily harm. Therefore, in defense of others, the defendant has the right to use the force needed to avoid death or serious bodily harm to the person defended. The force used in defense of others does not have to be limited to the degree or amount of force used by the victim. The defendant has the right to use so much force as appears to be necessary for complete protection of the person defended, and which a person of ordinary reason and firmness would have believed to be needed to prevent death or serious bodily harm to the person defended. Where a person inflicts an injury or death on another person, you must be convinced beyond reasonable doubt that the defendant's actions were the proximate cause of the victim's injuries or death. The proximate cause is the direct cause. It is that immediate cause. It is the efficient cause. It is that cause without which the injury to the victim would not have resulted. There must be a chain of causation from the defendant's actions until the time of the victim's injuries or death. Proximate cause does not necessarily mean that it occurred immediately prior to the injury or death. There may be more than one proximate cause. The acts of two or more persons may combine together to be a proximate cause of the injury or death of a person. The defendant's act may be regarded as the proximate cause if it is a contributing cause of the injury or death of the victim. The fact that other causes also contribute to the injury or death of the victim does not relieve the defendant from responsibility. The defendant's act need not be the sole cause of the injury or death, but must be a proximate cause contributing to the injury or death of the victim. Negligence on the part of someone else would not relieve the defendant from criminal responsibility if the actions of the defendant were the proximate cause of the victim's injury or death. Ladies and gentlemen, I have declared the law to you through these instructions to help guide you to a verdict. Whether some of these instructions apply depends on what you find to be the facts. The fact that I have instructed you on various subjects in this case should not be taken as indicating an opinion of this court as to what you should find to be the facts or as to what your verdict should be. Your verdict must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree. Your verdict must be unanimous. All 12 of you must agree on the verdict. The verdict cannot be based on sympathy, passion, prejudice, emotion, or any other consideration not in evidence in the case. Disagreements may arise during deliberations and your debates may become spirited. I urge you to be courteous to one another and respectful of your fellow jurors' perspective as you work toward a verdict. Remember, at all times, you are not partisans favoring one party over another. We're the judges of the facts. Your sole interest is to determine whether the state has proved the defendant's guilt to the charges beyond a reasonable doubt from the evidence presented to you in this case. Again, ladies and gentlemen, your verdict must be unanimous. Madam Floor Lady, when the jury agrees on the verdict, you will fill out the verdict form, which I have here. It is very self-explanatory. It will go back with the evidence. After you've reached the verdict, Madam Floor Lady will fill out the verdict form and sign. Then knock on the jury room door and inform the bailiff you have reached the verdict. At that time, we'll receive you back in the courtroom. We'll ask you to return to the jury room and not begin deliberations until you're told by the clerk or the bailiff to do so. There are a few more matters of law that I need to discuss with the lawyers before you begin your deliberation. All right, so I'm going to ask you to help back. I believe your lunch is already here. So y'all can get started with that. We'll be with you very shortly. I'm going to ask the alternates to please stay with us. Exception to the charge of mistake.
None, Your Honor.
Any exception from the defendant?
Your Honor.
Judge, can you indulge us for a moment? I need to find something. All right. Give me a minute.
While y'all are working on that, our alternates, you are now excused. You do have lunch back there. But thank you for being here. Again, like I said from the outset, we can't do our job without folks being willing to show up. It's very, as you can see, it's a very important job. So again, thank you for being here. You are excused. I've always told you, you certainly have the right to discuss your observations with the lawyer. Sometimes the lawyers would like some input, but you do not have to. If anyone contacts you in any way about this case and you feel uncomfortable about it, you call back in through the clerk's office and I will take care of it. If you're free to discuss the case with anyone at this point that you see fit, again, you certainly have the right not to discuss it with anyone. Again, thank you for being here, and maybe we'll show you that.
Well, I think first, maybe we start to go through the exhibits to expedite matters first. Thank you.
Quiet, please. I would like to just go ahead and, as to the elements of self-defense, I believe Your Honor charged. Okay. With respect to the self-defense charge, said that it was up to the defendant to show these various elements of self-defense. And of course, you also said it was the burden of proof on the state to disprove those elements, or any one of them. And I just would like to put on the record, I think that may be burden shifting as to this defendant being required to show, and sort of contradicts the defendant could rely on the state's failure to prove those elements. So I just want to go ahead and put that on the record that I think that may be error, and that would be off.
Well, I guess my question to you, how would the state prove something that the defendant never showed?
Well,
I don't know how else to describe it. I mean, I understand what you're saying.
yeah, it just troubles me because, I mean, I tried a lot of self-defense cases, but I just don't remember the charge being exactly like that.
I have not changed it in the 4 years I've been on this. Not saying I'm right or I'm perfect, but that's what has been in the standard charge.
And I understand. I just want to, if down the road the court decides that that is burden shifting, I just want it to be on the record.
You are on the record and have a certain possible.
That's the extent of the argument.
Okay, otherwise no other exceptions?
No,
Only subject to our original request, Your Honor.
Yep. All right, are the exhibits ready?
Not yet, Your Honor. We're just going back and making sure there's a clean copy of the state's 7 goes back. There was, I'm sorry, defense 7. There was Carter and the defendant, Mr. Chow. We just want to make sure that's the clean copy, the proper copy goes back. And we're just going through the count right now, Your Honor. So we'll move quickly.
Can I write a couple of things on?
All right, don't slow down.
I'm not sure if the jury is deliberating yet or not. The judge certainly gave them the instructions not to start deliberating until the evidence was sorted out and the exhibits were sent back to the jury room, and then the bailiff would give instructions on when to start deliberations. But we saw a pretty distant closing argument from that lead prosecutor this morning from the prosecution. But then Byron Gibson, the Fifth Circuit solicitor, had final remarks in closing arguments, and I felt like he made a very compelling and lasting impression on the jury. Now, currently, our poll is sitting at 86% guilty, 9% not guilty, and 6% undecided. I think when you put yourself there in that situation, and you think if somebody did have a gun pointed at you, but there was no testimony to that whatsoever, other than the Chows, and that was pointed out several times by the prosecution in their closing arguments. Sean Kent, the defense attorney, with his brunt style, delivering just loud and jarring closings there that we saw in the courtroom. So that is his style. A lot of people don't like Sean Kent, but I think a lot of those same people would hire him if they were charged with murder. So he is a fine attorney. So he's definitely a strong, dominant figure in a courtroom. But this case is not as circumstantial as it seems. I mean, we saw a lot of evidence in the case, and the forensic pathologist that testified also testified that he was shot in the back, and that was undeniable. So we're still outside the jury's presence. That's why there's no sound right now. The courtroom is just kind of shuffling around. But if they go to put anything on the record, that will be, they will turn the sound back on. The other thing, once the jury starts deliberating, if they have any questions, then we'll tune back into the courtroom and zoom in for those questions. A lot of times you can find out what the jury's thinking or what the jury's hung up on. Now, they did dismiss those 3 alternates, and Lee in our YouTube chat said that, what did Lee say? That the jury is composed of 7 men and 5 women. So we're curious about that. The penalty for murder, in which Rick Chow is charged under South Carolina Code Annotated 16320, a person convicted of or pleading guilty to murder must be punished by death or a mandatory minimum term of imprisonment for 30 years to life. So it would be 30 years to life. We know the death penalty is not on the table for this case. Lots to consider here. Cyrus was 14 years old, and he did not steal anything from this store as the owners suspected, and that is their reason for chasing him. We heard the prosecution ask, a couple days ago, how far were you willing to chase him? And how much were you willing to keep going? At what point would you have stopped? And Andy Chow, the son, who the defense claims Mr. Chow was protecting, said, I don't know. He did not know. So he's definitely had a lot of time to think about it. Thursday marked 3 years, and the family of Cyrus was in court on that 3rd year anniversary on Thursday since his murder. And then something that was so compelling to me was when they showed the video and you got to walk that route of them walking and running, Cyrus walking out, them running out behind him, and all the way to where he took his last breath. That was a long ways, and I thought we were going to stop at that first little alcove, but no, kept going. And we also saw a flash where they accidentally showed one of the autopsy photos, but it was of his leg where he had tripped and fell and sustained an injury there. And we didn't see it for long, but I saw enough of it to see that it was a pretty substantial injury on his leg from falling and then getting back up and then falling again before being shot in the back by Mr. Chow. So I'm going to play a couple pieces of testimony that we've seen throughout the trial. Of course, I'm continuing to listen in. If they turn the sound back on in the courtroom, I will zoom in quickly to that. so that we don't miss anything. But have a look at the first witness testimony. This is a lady who was, pulling into the gas station and then saw the commotion. They kind of ran in front of her car, and she was with her daughter, and they called 911, and then they go to the scene, and she tried her best to help Cyrus and to stay with him. And she breaks down in her testimony, just describing the moments where she felt convicted to stay with him so that he would have somebody with him. And then the prosecution pointing out a moment ago that Rick Chow being the last face that he saw. Anyways, let's have a listen.
It was not pretty. And you yourself did not. Do you know how to give mouth-to-mouth
I
assistance?
did not know. That bothers me today. And I could not help him. And the only thing I could do was just clear his mouth with the leaves. And I couldn't do anything else but to stay there with him. Because he didn't have nobody there with him.
But Mr. Chow did apparently give mouth-to-mouth resuscitative efforts to save his life. Right there in front of him. That's all we have, Your Honor. Thank you.
Hang on, ready, ready.
Do you need a moment?
That was riveting testimony in this trial. And then, we heard a lot about Mr. Chow helping to preserve the life of Cyrus after allegedly shooting him in the back. But, malice is not, or you don't have to prove intent with murder. It's not required in South Carolina. So they don't have to prove that he intended to murder him or that he hated him or that he was racist or anything like that. They just have to prove that it was murder. So the facts of the case, the Chows thought that he stole a bottle of water. And then Alice Chow, we saw in that photo in the still from the surveillance footage that Alice Chow actually confronted Cyrus in the store before ever running out. And then there was a part in Andy Chow's testimony where the prosecution was trying to get him to speak, basically, to retell his account of what happened. And there was this pause moment where he was like, I'm not sure if I can say that. And he's kind of looking around the courtroom. And, witnesses do get coached from the defense, before, and from the prosecution, before they testify in open court. So, and there's facts about this case that were not allowed to come into court through, pretrial motions. And so there are things that he was not allowed to mention, but we do know from the records that Alice Chow yelled out to Rick and I guess Andy before they chase after Cyrus. I don't know what she said to them. I believe it was in Cantonese. But we don't know what she said. And that is what prompted them to run after Cyrus. But she had already confronted him. She thought he stole that water that you see him taking out of the cooler. But then later in the footage, we see him putting it back. And I just thought that was very powerful. Now, we're going to go to look at a clip from the testimony that was kind of uncomfortable. It's from Andy Chow's testimony. If you see me looking up, I'm kind of keeping an eye on the courtroom as well. Anyways, he's so hard to get information out of. And he lived this scenario, and I'm sure, his dad's been in jail for 3 years. So I'm sure he's been thinking about, and this is replayed in his mind over and over and over. I don't know why it was so hard for prosecutors to get answers out of him, especially when it comes to who was chasing who. At one point, he even claimed that Cyrus was chasing him. Not true.
And you had mentioned that when you were driving by the scene, you were going at a very slow pace.
Yeah.
And if there was video of your car not going at a slow pace, would you disagree with that?
Yeah.
And so, how fast would you say you would have been going?
I don't know.
I need you to guesstimate because you said you were tracking them. So how fast you going? 1 mile, 2 mile?
I don't know. I can't answer that. I don't know. I don't remember.
You had mentioned in your testimony that you did not see anyone throw anything. Is that correct?
Yeah.
And you said you saw the book bag laying directly on the ground?
Yeah.
And it just had fallen?
When he fell, the book bag fell. The first time.
Immediately at the same spot?
Mm-hmm. Well, no, I wouldn't say the same spot. I can't remember exactly where, but I wouldn't say the same spot. I think it kind of fell down, so I can't really remember.
Well, you testified to it, and so that's why I want to make sure. You testified on direct that it fell right there. So if you want to correct that now, please.
I mean, can you explain what right there is? It could be here, it could be there. You're saying right there. I don't know what right there is.
Well, I need to know because that was your testimony. Where did the book bag fall?
On the ground.
Where?
I mean, I have to look or something. I can't just say where exactly it was on the ground.
You saw the book bag?
Yeah.
You saw the book bag on the ground?
Yeah.
It was not down a hill in some grassy area. You personally saw it?
Yeah, it was on the ground.
Okay. And your testimony is you personally saw the shoe come on?
Yeah.
Now, this witness, there was, he had a prior criminal record. And so the defense tried to basically just say that he's not a credible witness. But I found him to be very credible. In fact, he wanted to be very exact about where that book bag was. And the defense was trying to just get him to generally say where it was. But he wanted to be exact about that. He did not want to provide information that wasn't 100% accurate. So then we had, I believe the medical examiner is what we have next. And she was very precise about what happened, the angle it happened, and where it happened.
Okay, for those of you that may not have been able to see the press conference, yes, I would like to address the fatal shooting of a 14-year-old.
Rewind it back. This is actually the coroner, Nida Rutherford, and this was played like right after the murder of Cyrus, right after the press conference that her and Sheriff Lott did. And many criticized her being vocal. I mean, she has a very active social media presence, and does a lot of like community interaction and stuff like that with her position as coroner. Commenting on ongoing cases is not something the coroner usually does, but they had just done the press conference, and this was kind of her after remarks, I guess. Anyways, have a listen.
Okay, for those of you that may not have been able to see the press conference, yes, I would like to address the fatal shooting of a 14-year-old young man who died at the hands of a local store owner. He is being charged with murder. The death will be ruled as a homicide. He was shot fatally in his back as he was running away from the store. I want to be very clear because I've seen lots of things on social media. Yes, he was shot in the back. Yes, he was running away. No, he did not shoplift anything from that store. I want to be very clear about that. The video footage that we have seen shows him picking some items up, not stealing them, and then he politely and quickly placed the items back where he found them. He was shot not on the store property. He was shot as they were pursuing him away from the property. So I want to be very clear that as we are looking at things on social media, that we are reading the right narrative. I am the coroner for Richland County. I work collaboratively with the Sheriff's Department, but we must perform our own investigation, and we do that using the body. We use it doing science. They have their whole criminal investigation that they do. I have personally seen that the alleged murderer has been placed into custody. I stayed, I waited. As I was walking out of the Sheriff's Department, I literally saw him being escorted in. He is in police custody. So for those people that are saying, he was not apprehended, yes, he has been apprehended. He is in the sheriff's department custody. The 14-year-old who died, his name is Cyrus Carmack-Belton. We want justice for this.
Still not much going on there inside the courtroom. There's a couple other clips that I was going to play. The lady who actually gave Cyrus chest compressions, she testified that Andy Chow assisted her, and it was just a very bizarre, and I don't play this for like clickbait or anything. I've just never seen anything like this, what she described, and it was just very bizarre to me. Anyways.
As I was doing chest compressions, he was doing mouth to mouth. He was sucking the vomit out of Cyrus's mouth, and he was spitting it to the side of him.
Hold up. Let me go through that again with you. What do you mean he was sucking the vomit out of the young man's mouth?
Cyrus had vomit in his mouth and his airway, and he bent down and put his mouth over Cyrus's and was getting the throat out.
As he was doing the mouth resuscitation?
Yes.
Have you ever seen anyone do anything like that before?
No, sir.
But is there any doubt he was trying to get away from you two?
I don't know what he was thinking. What he was.
Was he running toward you or away from you?
I was running away from him. Now that
Let me
he's
ask you
pointing a
something.
gun
Let
at
me
me.
ask you, I'm going to make this real easy for you. Okay, step by step.
Okay.
When y'all left the Shell station, was he trying to get away from you two?
I'm not sure why he ran.
Did he ever stop and ask to shake your hand?
No, sir.
Did he ever run towards you?
No, sir.
Okay. He was running away from you, right, Andy?
I can't speak for him.
Was he running towards you?
No, sir.
Was he running away from you? It's not a hard question.
I guess not to me, yes, sir.
He was trying to get away from where you were, correct?
Could be.
It could be. You and your dad are yelling at him and running after him.
I did not. Outside of the store, I did not yell at him.
You yelled at him in the store.
Well, I called out to him, hey.
And your dad yelled to him when he got out of the store.
And my dad called out hey to him, yes.
And he ran away from you.
Okay, yes, sir.
I'm asking you. This is your chance to answer my questions. And they're not hard, are they?
No,
He
sir.
ran away from you and your father, did he not?
He did run away from me.
Okay. Thank you.
Okay.
At any point did he turn and engage with you? You understand that word?
He did not.
Okay.
So he says at no point did Cyrus turn and engage with him. Yet the defense paints a story as if he did. It continued to get like more aggravating to get answers out of him, and the prosecution got even more heated. Take a listen.
When did you start running?
After he ran.
Why? Is there anything wrong with him running?
Well, I ran because I thought he had stolen something, and I wanted to see where he was going.
Okay. How far were you going to chase him, do you think?
I'm not sure. Just going to see where he was going.
A mile? What if he had run a mile? Would you have kept chasing him with your dad?
I'm not sure. I'm not sure what I was doing.
You don't know at what point you stopped chasing a 14-year-old?
I don't know when I would stop.
Okay, and then there's this last moment that I think was probably the most heated moment of the trial, and it's where the prosecutor just screamed at him, deservingly.
Who did you tell that day that he pointed a gun at you?
I did not say the exact words, no, sir.
What am I doing right now?
Pointing at me.
Yeah. It's a very simple word, is it not?
Yes, sir.
Okay. You never say pointed. You never use the term aim, did you not? Or you didn't, did you?
I did not. I did motion and pointing.
Never said point. You never said aim. You said he pulled a gun. I saw a gun.
Yes, sir. I said those things.
Okay. English is your first language, correct?
Yes, sir.
Do you even turn point? You use it all the time, do you not?
Yes, sir.
You understand the word aim, correct?
Yes, sir.
Did anybody stop you from using those words that day?
No, sir. They also did not ask me.
Did you have trouble volunteering that very important piece of information?
The first thing that came to my mind was he pulled it, and then I pointed with my
He
hand.
pulled. Could it have come out of his pocket when he took that violent fall to the ground?
I believe he took it out.
Could it have come out of his pocket when he took that violent hit on the ground that dislodged the flashlight from his gun?
I'm not sure.
Could it have fallen out of his pocket after you chased him 130 yards and he hit the ground, wounding his shin, dislodging that light from his gun? Could it have come out of his pocket at that point?
It could have.
Okay.
I think those words are going to sit with the jury, and anybody who's ever wore a sweatshirt and moved around a little too much, anything in the front pocket of that sweatshirt is bound to come out. It's definitely not secure. So the fact that he fell twice, or fell once, then got back up and then fell again, I think it's very possible that the gun possibly fell out. And as Andy and his dad both told investigators on scene that day, I saw a gun. They never said he pointed it. They never said he presented it. And Andy just admitted that there. And then this is the clip that I was talking about where the prosecution yelled at him. And I mean, they screamed. And even Sean Kent, who is known for, being loud in a courtroom, was like, "Your Honor, please."
Anything else briefly?
It doesn't happen if Cyrus doesn't put a gun on you either, correct?
Correct.
Thank you. No further questions.
Anything else to say?
You don't even know there's a gun if you stay in the gas station!
That's what matters.
Right?
Your Honor.
You don't know he's got a gun if you stay put in the Shell gas station, correct?
Yes, sir.
I'm correct.
Yes, sir.
Thank you.
Yeah. Yes, sir. You are correct. If he'd stayed in the gas station, 14-year-old Cyrus would be alive. Anyways. All right, well, the future of Rick Chow is in the hands of 12 of his peers as a jury decides his fate. He's facing a minimum mandatory sentence of 30 years to life in South Carolina Department of Corrections if he is convicted of murder. And keep in mind that this case, which the jury doesn't know this, but this case already had a stand your ground hearing, which was denied. And that's why the trial was scheduled and the case proceeded to trial, which now we're on day 4 of. This is the very end. The state just gave its closings. Defense just gave theirs. Jury has been sent back. They have food and the exhibits. Court is in recess. Everybody's kind of gone to lunch. So once that lunch break ends, court will come back. We'll still have the standby slide up on the courtroom while the jury deliberates, but we will be monitoring the courtroom in case the jury has any questions. And if they do, then we'll immediately tune back in. But stay tuned. We never know how long it's going to take a jury to deliberate. So we'll just keep an eye out and stay tuned. we're playing the video footage on screen of kind of the synopsis of what happened inside of that store. And you can see this is where they chase after him. He runs out of his shoe. See that shoe fly off, and then they cross the street and continue chasing him a really long way. So back to the beginning of the video, we see Cyrus is in this cooler, and his hands are in his pocket. The cooler door closes. She's perched right behind him, watching every move he makes. It looks like Andy is zoomed in on him as well. So he has two people watching him. He gets to the front door, and this is Alice Chow, calls him over and confronts him about what's in his pocket. And he shows her, and he says to her, I don't have anything in my pocket. I could show you, I don't have anything in my pocket. And then he calmly walks out of the store. He doesn't run out of the store, he just walks out of the store. And then she says something to them, and then they chase after him. And he had rounded the corner of that store, and then he takes off because he knows that they're behind him. Probably doesn't even know why. And they chase him down. Poll right now for guilty, not guilty, or undecided. We've got 87% saying guilty, 5% saying not guilty, and 7 undecided. So if you still have not cast your vote here on what you think the verdict is going to be, certainly let us know. Currently, the jury is deliberating. They've been deliberating for 42 minutes now. And, we're continuing to keep an eye on the courtroom in case the jurors have any questions. They say a fast jury is often a guilty jury. But we shall see. The prosecution laid out a good closing argument this morning, especially Fifth Circuit Solicitor Byron Gibson, who gave the final closing arguments. The defense, just nothing we haven't heard. They just keep reiterating that he had a gun, and we know that he did. We don't know, if he pointed or presented that gun or not. It's very possible. In fact, Andy Chow said on the stand that it was very possible that Cyrus just lost that firearm as he was running and as he fell. So, I always feel like in trials we don't show enough of the actual victim, but we do have just a few pictures of him that I would like to put up. This is 14-year-old Cyrus Carmack-Belton, who lost his life on May 28th, 3 years ago, 2023. Very young, neighborhood kid. We haven't heard anything about him being a troublemaker. Seems to be a respectful child. His family is packed courtroom 3A every day. Even on the 3-year death anniversary, they were in trial on Thursday. So it's been quite a trial. So we will see if the jury has any questions. We'll be continuing to watch. In the meantime, we are going to have that standby banner up. But if they do have any questions, of course, I'll bring you guys back. We'll go right into the courtroom. But let me know in the chat what you guys are thinking. If you've tuned into the whole trial, if you're just now tuning in, if you've seen parts of it, pieces of it, what your opinions are. I'm curious. It's been an interesting trial. And the Chows have probably the best defense team money could buy in South Carolina. Some really, really big name powerhouse attorneys on this case. And this is where we are. Jury deliberations. And now Chow's facing 30 years to life imprisonment in South Carolina Department of Corrections. And if he is convicted, he'll be moved to what we call reception. They'll shave his head if he has any hair, and he would be there for the first little while. And then usually the South Carolina Department of Corrections will send people closest to where they're from to make visitation easier and things like that. But we'll see. We'll see what the jury decides in this case. Stay tuned. We've got, 45 minutes on the clock now. So we know that they were kind of eating lunch and that sort of thing too. They had a few minutes to eat before deliberations begin. But the exhibits are back there. They're in their hands. And it's up to 12 of Chow's peers. What happens? We'll see. Stay tuned. Jury deliberations are underway outside courtroom 3A in Richland County, South Carolina, as the family of 14-year-old Cyrus Carmack-Belton pray for long-awaited justice in this case. Chikai Rick Chow, a former convenience store owner, is accused of chasing 14-year-old Cyrus Carmack-Belton 130 yards out of his shoes before the teen fell, dropping his backpack. Now, the prosecution argues that Rick Chow shot the teen in the back with a 14 caliber handgun, claiming that it was self-defense, that he was defending his son Andy Chow, who testified in open court that the victim in this case raised the gun and pointed it at him. Now, none of the witnesses who saw the incident and testified in this case on behalf of the prosecution saw that or reported that. Also, Andy nor Rick reported that the day of the murder. They were interviewed roadside by 2 different officers. That body cam played in open court. Neither one of them mentioned that Cyrus pointed or presented the firearm at him at all. They said they saw a gun. The prosecution brought up a good point. He said if Cyrus was 26 years old, would we be having this same conversation? I think the answer to that is yes, but the conversation would be different. I think the charges would be the same, but what people are trying to say about Cyrus having a gun on him would not factor into that conversation because he would be an adult. So, merely having the gun on him, and the prosecution does not deny that that is against the law. He should not have had a gun on him. But whether or not he presented and pointed that firearm or not. Also, when the lady stopped to do CPR, nobody told her, hey, be careful. He just pointed a gun at me. And that would be very valuable information, I would think. We're going to look at this body cam, or this convenience store surveillance footage again. We know that they had a very state-of-the-art system with uber amounts of storage. This is kind of their thing, was catching shoplifters. Their system even had like facial recognition. So if somebody came in and they stole something and you had that footage, you could then tell their system, hey, this is a known shoplifter. They testified in court that they did not know Cyrus. They did not have any prior memories or altercations with Cyrus. So this was, they also had a wall of shame, and that was kind of contested by the defense on whether or not they could bring that up and how many times they could bring that up. But they brought it up enough to where I think they made the home run to let jurors know that this is a serious, obsession of theirs. I mean, in the video footage that you see from the store, which I'll go ahead and play, actually, I think this is kind of towards the end of it. So let's start it back here. You see Cyrus over by the cooler. He's pulling out water and then putting it back. You see Mrs. Chow there, and this is Alice Chow, and she's literally following him around the store. In another video, we saw her standing up on a shelf, peering over it. So, I mean, they're just hyper-focused on him. And then here we see Andy Chow, who's working the cash register. You see him kind of lean in, and you can tell he's looking at what looks to be like Alice Chow talking to Cyrus. And then as the video goes on, Cyrus is walking towards the door, and Alice Chow comes out and she confronts him. This is Alice Chow confronting Cyrus. And you see him turn around, and she confronts him about what he's stolen from the store. And he shows her his pocket, and he says, I didn't take anything. I don't have anything. Clearly he didn't unfold, turn the pocket right side out. He did have a gun in that sweatshirt. And the prosecution argues that it fell out. And Andy Chow on the stand even testified that it is possible that that gun just fell out. Now, if the gun had fallen out, then, and Cyrus fell down, then how would he have pointed and presented it? So when Andy Chow said on the stand, yeah, it's totally possible that it fell out, I was just thinking, but I thought it was in his hand and he was pointing it, and you saw the inside of the barrel, which the prosecution laid out in their closing arguments. You could not see the inside of the barrel. The inside of the barrel is black, as is the rest of that .45 caliber handgun. Now the video continues. You see Cyrus showing his pockets. He's like wiggling it around. I don't have anything. I didn't take any water. This guy's peering on. Alice says something to Andy. Andy comes out from behind the register. He calls his dad and they take off. Now Cyrus is walking. You see him just casually walking. He turns the corner of the store. Now the Chows say that they walked out of the store, but it didn't look like they walked. It looked like they ran after him. So we're going to play back through this one more time. I just want to see it one more time. So he comes over. Alice kind of follows him to the front. Andy tunes in to what she's saying to him. They're conversing. Cyrus walks towards the door. She summons him again and questions him. I mean, she literally confronts him right here. All this over a $1 bottle of water. Our poll right now is sitting at 89% for guilty. All right, so they chase out of the store, and you see now Cyrus realizes, that's where he turns and realizes that they're after him. See both shoes on his feet? Now when he takes a left around this white car, you're going to see one of those shoes fly off of his feet. And from that point on, he's running with one shoe as fast as he can. They chase him across the street, and the prosecution showed earlier exactly how far that was that they chased him. And it was a pretty long distance from that store. I mean, they chased him across the street and 130 yards, quite a long way. And when they were asked why and for how far were you going to chase him and to what magnitude, the answer was, I don't know. I don't know. Everything was just going on. So, yeah, things are going on. Anyways, Andy Chow was born in Greenville, South Carolina, grew up in Columbia. He worked on weekends and during breaks, unpaid for his parents there at the convenience store. He says that he walked out of the store, but we clearly see him on camera running out of the store. He says he called up to Cyrus 2 times. So I'm assuming once when Cyrus fell, got back up and continued running, he caught up with him, but then he continued to chase him until Cyrus fell again. And then Andy says he saw that he had a gun. That's what witnesses, that's what Andy gave statement to when he first talked to authorities on scene. 2 different officers, he gave that same account that he saw a gun. He never said that he pointed it at him. He never said that he presented it. He just said that he saw the gun. Some people have asked about the convenience store now, and we do know that now the store has been sold. I've heard of some other instances where the Chows have allegedly used a gun. I don't know if they have shot somebody, if they have shot at somebody. I do not know. That is all alleged. But there are reports out there that they had, and I think over 140 calls to the police for just small theft of items in their store. And I understand that could be very impactful to a business. But you also can't chase down a 14-year-old and shoot them in the back and then claim self-defense just because in the event they end up having a gun. And then I didn't hear that it was a short day for the jury. I would suspect that the judge would want them to continue deliberations. There's other parts of the trial that you can break up, but deliberations, you really want to keep them going as long as you can while they're in clear thought. And they've just been charged by the judge, so they have a clear understanding of how they're to apply the law. Because remember, for the first 4 days of trial, they just get all of this information, but they've not yet been told how to apply that information. Then they had the weekend after hearing all of the information in the trial and then today they just heard closing arguments and the charge from the judge. So we've been in deliberations now for a little while, about an hour and 40 minutes, I think. So, and then somebody else had asked, when will the verdict be read by the judge? I'm not sure if the judge or if the clerk of court will read that verdict, but it won't be read until the jury reaches a verdict. So they're currently in deliberations. Once we find out that the jury has reached a verdict, the courtroom will come back and the verdict will be read. Then after that, the judge may do sentencing today. He may postpone sentencing. Never really know. And then we'll hear victim impact statements from the victims affected in this case and any character witnesses or character statements, I should say, for the Chows. And then after that, we'll have sentencing and if there's a guilty verdict. If not, then court would just be adjourned. So we're going to continue keeping an eye on the courtroom pretty closely, and we'll let you know if the jury has any questions. We'll also put that jury clock back up, and we'll just continue watching to see when the jury may reach the verdict in this case. Stay tuned. See a little bit of action going on in the courtroom now. The sound kind of is going in and out, but we don't currently have audio from that courtroom, but we're going to hang out here and see what's going on.
The instructions. With y'all's permission, I think I'm going to ask the poor lady exactly what part of the instructions they want. I don't know that it would be necessary for them to hear my job, their job, and all that all over.
You don't have a specific section?
Judge, you could just call foreman in, or lady?
Yes, maybe, let's start that way. That suit everyone, just bring in the four ladies?
Judge, yeah.
Okay. That's fine. All right, just bring in the four ladies, please. Yeah, and just for the record, I marked the note this court. Madam Forelady, we got your note about wanting us to read instructions again. Is there a specific provision in the instructions you have in mind, or does the jury want to have the entire thing read again?
They do not want the entire thing read again.
Okay.
We didn't know that we could have a portion of it read,
Okay.
but we did want to go over the aspects of malice, what constitutes malice.
Okay. All right. That was it.
Yes, and someone had spoke about what is the charge of murder and what are the things that would make him guilty of murder.
Okay.
And I think that's one and the same one we're talking about.
Okay. Well, that's what we need to know. If you'll step,
Okay.
or you can just stay.
Okay.
And you can get. What I think I'll do is I'll just read the entire murder section and stop after that before we get into this, because I think it flows right into separate notes. I'll just stop the section. Unless anybody has anything. All right, we're going to bring in the remainder of the jury, please, sir. Yes, sir.
All right, so we're continuing to watch here as the jury has two questions. They've asked for the judge to reread the jury instructions, as well as what constitutes malice and what is murder, or what would make him guilty of murder.
Jury seated, Your Honor. Thank you, sir. All right, ladies and gentlemen, jury, understand you'd like to be recharged on how we define murder. So I'm going to recharge you on the murder portion of the instructions. The defendant is charged with one count of murder. The state must prove beyond reasonable doubt that the defendant killed another person with malice aforethought. Malice is hatred, ill will, or hostility towards another person. It is the intentional doing of a wrongful act without just cause or excuse, and with an intent to inflict an injury or under circumstances that the law will infer an evil intent. Malice aforethought does not require that malice exists for any particular time before the act is committed, but malice must exist in the mind of the defendant just before and at the time the act is committed. Therefore, there must be a combination of the evil intent and the act. Malice aforethought may be expressed or inferred. These terms express and infer do not mean different kinds of malice, but merely the manner in which malice may be shown to exist. That is, either by direct evidence or by inference from the facts and circumstances which are proved. Express malice is shown when a person speaks words which express hatred or ill will for another, or when the person prepared beforehand to do the act which was later accomplished. For example, lying in wait for a person or any other acts of preparation going to show that the deed was within the defendant's mind would be express malice. Malice may be inferred from conduct showing a total disregard for human life. If facts are proven beyond a reasonable doubt sufficient to raise an inference of malice to your satisfaction, this inference would be simply an evidentiary fact to be considered by you along with the other evidence in the case. You may give it the weight you decide it should receive. That's it. I'm going to excuse you back to your jury room, and if you have any other questions, if you need anything else, just let us know. All right. All right, any exceptions from the state?
No, sir.
Anything for the defense?
No, sir.
All right, we'll be at ease.
All right, so the court at ease, 1 hour and 51 minutes, and now counting again on the clock as the jury has two questions. What is malice, and then what would be murder? What would he have to do to be guilty of murder? Malice or forethought, it's or, not and, so that's very important. Also, the malice doesn't have to be months before or weeks before. Or they had to plan it out. Or the next time we see so-and-so, we're going to shoot them. No, malice can just be in the heat of the moment, very quickly. And that is all in the inference of the minds of the jurors. The jurors decide the facts. The judge decides the law. So we have about 2 hours, close to 2 hours on the clock now, for deliberations. The fact that the jurors had questions shows that they are intently deliberating this case. They may be hung up, and some may be having a hard time with what would they do in this situation? What would you do in this situation? What would I do in this situation? I can tell you what I wouldn't do, and that's chase someone out of a retail business and then continue to chase them after they fall twice and then shoot them in the back. So I think that's where they went wrong. So we'll just have to see what the jurors think, what they decide. So we're going to continue watching this courtroom, and we will let you know if they have any other questions. But they could be wrapping up their deliberations and kind of solidifying everything now that they have clarified through a second charge of instructions now on the murder charge, which carries 30 years of imprisonment to life in the state of South Carolina's Department of Corrections. So stay tuned. We'll go back into the courtroom if they have any other questions. In fact, I'm just going to put the courtroom up. I think you can still see the clock ticking with the courtroom in the background. So we'll just leave that up, and that way we'll be ready if they do have any questions. while we're waiting on jury deliberations, I'm going to play that medical examiner again, some of her testimony, just so we can look back at different parts of the trial.
The most notable finding was a gunshot wound entering his right back.
Okay. What about other superficial type wounds?
There was a partially healed injury on his right hand, and there were some abrasions on his right lower leg.
I want to show you states 77. Does that accurately reflect the abrasions on his leg?
Yes.
Okay. And did these appear to be recent wounds?
Yes.
Okay. The location of the wound on his back, say that one more time.
It was on his kind of right back area, just below kind of mid-back.
Okay. And that states 80. Does that fairly and accurately represent what you yourself witnessed?
Yes.
Okay. I want to show you what's been introduced to state 79. Do you recognize that?
Yes. This is a photo of one of the x-rays we took before we started the autopsy. So before we do autopsies on gunshot wounds, we x-ray the body to make sure we know where the bullet is, if there's a bullet in them, to make sure we recover that so we can hand it over to law enforcement. He's on his side.
Okay, I was about to say, so where his head would be to the right of the screen?
Yes, his head's to the right, his legs are to the left.
Okay, yeah, and I guess his buttocks would be at the bottom left corner there?
Correct.
Okay.
And he's kind of boosted up on a body block so we can shoot across the table.
And, okay. Dr. Garrison, what is this object right here that we're seeing in state 79?
That's the projectile we recovered from the body at autopsy.
Okay. And this is just this is an angle, different angle, but this is state 8. Do you recognize that?
Yes, that's upside down. But this is an x-ray going front to back of the body, again showing where the projectile is located. So it's just left of midline, as you can see.
83 is not in yonder, but we're all from state 83 for admission now.
No, yes, no.
Already been moved to state 83.
Okay, this is a little, in state 83 again, this is what?
That's the projectile, and you can see the shadow of his heart just above that.
This is his heart?
Yes.
Okay. And correct me if I'm wrong, but his head would be, this is basically looking at his head being up, his feet
Correct.
being down. I even see, I think, an arm right here.
Yes.
Okay. What were your general findings as far as the bullet wound? Did it have an exit?
It did not exit, no.
Okay. Let me show you, it hasn't been introduced yet, but do you often, or I guess rather, probably all the time, do you draft something like that when you do an autopsy?
Yes, so we have a stack of blank male, female, all sorts of diagrams that we take notes on when we do the autopsy. And then I kind of do my report based on some of the notes I take on there.
Okay. And this is not scale, right? Is it? This is just kind of.
No, it's a generic male diagram.
Okay. You want to state off for state 73 for admission?
No objection.
Would be moved to states 73 without objection.
What were your general findings as far as the? We already said it didn't have an exit wound, but the bullet wound that was found in his back, you said it was his right lower back?
Right, so it's the right lower back. It was just under 2 inches right of midline, 46.5 inches above the heel. It was a classic entrance wound. So entrance wounds have what we call an abrasion collar. So as the bullet enters the skin, it kind of rubs the edge of the skin and drags it for a split second on the way in. So that's a typical entrance wound, which this had. The other things we look for when we're looking at bullet wounds in autopsy is we look for soot and stippling, because that's going to kind of tell us if there's a clue as to how close the shooter was when they were shot. So if there's soot like in the wound, that's usually a contact wound. If there's soot more on the skin around the wound, that means the gun was usually within 6 inches. If there's stippling, which is actually the gunpowder that comes out of the end of the gun and has tiny little abrasions on the skin surrounding it, that's usually within around 18 to 24 inches. The exceptions to those, of course, if it goes through like an intermediate object like a car door or a wall of some kind, and also very thick clothing can block those things. On this case, I did not see any soot or stippling, so this is what I call indeterminate range, meaning I don't know if it's 2 feet away or 20 feet away.
Okay. So no indication of sooting or stippling. So
And then, so after we track the bullet, it comes in, it goes through, it kind of hits the 11th rib, so we have 12 ribs, so just above the bottom rib. It hits part of the rib and part of the T11 vertebrae, so the 11th vertebrae going down the thoracic vertebrae there. It then goes through the right lower lobe of the lung, and then it goes through the right ventricle of the heart. So this is the most deadly thing that happened, is that it goes through his heart. That's not a survivable wound. It then goes and after it goes through the heart, it hits the inside of his rib cage. We're actually able to see when we remove the front of his rib cage where the bullet impacted. So it's actually a little higher up than where the bullet's found. So the bullet, because of the way it kind of mushroomed, got caught on the pericardial sac, which is the soft tissue sac that surrounds the heart. So it kind of pulled it back down, but it actually impacted further up and to the left.
would it have been immediately fatal, or would you expect to see somebody live for some time period after this?
So it's not immediately fatal. Those are more, and he would not lose consciousness immediately. Those are more with wounds to the head. So with a heart wound, maybe a minute or two, he could have, there's been reports of people being able to run with the adrenaline in their system, but not far. They collapse pretty quickly because the blood, every heartbeat is the blood's coming out of their heart and not circulating.
What is it that kills you? Is it
the blood loss? So instead of the blood circulating in your vessels and going to provide oxygen and energy to your cells, such as your heart, brain, vital organs, the blood is accumulating in his chest.
Tell me about midline is his backbone, is that?
Yes.
How far from midline, left or right, was the wound?
The entrance wound was 1 3/4 inches right of midline.
And as far as the trajectory, was it, I guess, assume back to front? There's no exit, and it's the holes in his back.
Correct. So it's back to front. It was going a bit upwards, and it's going just slightly right to left. So it goes from just right of midline to just left of midline.
Okay. Let me, with court's permission, can Dr. Garso step down for a minute?
Sure.
Show me kind of on my back, just use me as a model, where would that entrance room be?
So if we go mid-back, just underneath that, just right at midline, I would say approximately in this location here.
Okay. You can figure, show the jury.
I would say right around here.
Hold on. It's an old shirt.
Okay. You want me to draw on you?
Show me what it is.
Okay. Never drawn on an attorney before.
Okay. Any trajectory was upward, you say?
Yes.
Okay. Show me with an X on the front of me where. Would it be on this side or this side?
It's going to be on the right side.
Okay. And do you need any notes or do you?
Turn around again. Oh, the left side, sorry, the left. Okay, so left, and it's, can I feel the bottom of your sternum? So it would be approximately here-ish.
Okay. Now with this rod, stand to the side. Show during my profile generally where that would be, how that would look going into Mr. Carmack-Belton's body.
Say it like this. If he was standing straight up.
Okay.
The problem is like my diagram, everyone's standing in anatomical position. No one is ever really standing in anatomical position when they get shot. So.
Well, I got one more. Did you see my toy gun? It's not a workable gun. It's You've seen this too, Dr. Garcia.
I have, yes.
If you're in a shooter's stance, if that was testified to, okay?
Okay.
Stand with the jury, or they can see you, and I'm over here.
Do you want me to put this down?
Yeah. Would you expect to see that trajectory if you're in the shooter's stance and you're behind me and I'm upright?
So a lot of times we get people, if someone is behind you with a gun, in general, someone's not going to stand there. A lot of times we have upward trajectories from people bending over.
Okay. The victim bending over, you mean?
Yes.
Let's just for argument's sake, you're the shooter and you're in a standard gunman stance. I am upright. Would you expect to see the trajectory that you observed on Mr. Belton?
No, so either the shooter would have had to be below you shooting upwards, or the victim would have had to be at an angle downwards, or he would have been uphill. There's a few different variables, but generally not straight if we're on flat ground and I'm directly behind you.
Yeah, testimony is we're on flat ground.
Okay.
Okay, and you're standing upright in a shooter stance.
Got it.
Would you expect this trajectory if I'm hunched over running from you?
Yes, that would make more sense.
Okay. Now, would you expect this trajectory if I was turned in any way like this?
Not from right behind you, no.
Okay. But you would expect this trajectory, would it be consistent with somebody running away in a runner's stance with their back directly towards you?
Yes, if I fired the weapon from here with you in that stance,
Okay.
especially with you just twisted just a tiny bit, that would be consistent.
If I'm for some reason turning around aiming at you, like I'm doing now,
Yes.
is it possible to have this trajectory?
No.
Thank you, Dr. Garcia. In your expert opinion.
Okay, that was the forensic pathologist employed by the Medical University of South Carolina who performed the autopsy on Cyrus and was explaining how the bullet projected through him. Also, there was a crime scene investigator who attended that autopsy, and he was more on the law enforcement side of collecting the evidence out of that autopsy. And I want to go to his testimony now, and we're continuing to keep an eye on the courtroom as well. So we'll let you know if the jury has any questions and we need to go back.
But is there any doubt he was trying to get away from you two?
Ms. Dewey, could you tell us what we're looking at in this photo?
This would be a photograph of the projectile that was collected at autopsy.
Okay. And it was, you got it from, where'd you get it from? Who'd you get it from?
I received it via a chain of custody form from the coroner's office.
Could we show 75 minutes? Could you tell us what we're looking at here?
This would be a shoe that was collected from the autopsy. that was said to have belonged to the victim.
And yeah. And is that the same item, just a different angle?
That's correct.
And we show 77. Can you tell us what we're looking at here?
If I may refer to my notes so I make sure I tell you correctly. That would be an injury that I photographed to the right shin.
The right shin of the victim in the case?
That's correct.
Could you tell us what this is?
That is just another angle of that same injury to the right shin of the victim.
Court's indulgence?
I do want to point out on this part, they're not showing the photo of that injury to his right shin, but Cyrus ran from Andy, the store owner's son, and he fell, and Andy said that he caught up with him, but Cyrus got back up and took off running again before he fell the second time, and that's where Andy caught up with him again, saw that Cyrus had a gun, he yelled that Cyrus had a gun, and his dad shot him in the back. But the fall that he sustained the first time, it was a pretty substantial injury. They're not showing the photo of it now, but they did accidentally kind of flash it earlier. Actually, in closing arguments, we saw that. And it was pretty bad. So, back to the prosecution's, case in this is, at what point would you have stopped? How far would you chase him? To which Andy replied, I don't know. So I want to continue listening to this testimony.
While you were at the coroner's office, did you notice anything on the victim's body? Did you notice anything on him at all? As far as on his... did you notice anything?
Do you mean like clothing items, injuries?
When you got there, was he clothed or was he unclothed?
The victim was nude at the autopsy.
What, if anything, did you notice on his back?
I noticed an injury to the victim's back.
Was it something that you took a photo of?
It was.
Would you recognize that photo if I showed it to you?
I would.
Your Honor, the state's approaching the witness with what's been marked for identification purposes. It states 80 and 81. Stop showing those to the jury. Do you recognize what I just showed you?
I do.
Are those photos that you took?
They are.
Are they materially different from the photos? Do they look changed in any way?
They do not look changed.
Your Honor, at this time, the state would offer Exhibit 81 and states 81 and 80 into evidence.
Well, Your Honor, our objection is that he's not going to be questioned about what it is if they want to introduce the photograph, but this is a medical question for the pathologist. And so I don't think this witness is competent to characterize what it is. So I have an objection. I don't object to the admissibility of the picture per se if he took it. I do object to any further testimony.
I'm going to jump in for a second on this. So usually in an autopsy where you have a medical examiner, some medical examiners are forensic pathologists, and they have been forensically trained to perform forensic autopsies, which would be required in the event of a suspected homicide. And most of the times the coroner's office will attend that autopsy as well, and a law enforcement official. And in this case, it was a crime scene investigator who attended the autopsy. They will take their own photographs, and the ones that the medical examiner takes, or the forensic pathologist, who's actually head of that autopsy and in charge of the report, they take other photographs to scale, and usually it's the assistant that takes his photographs, but they'll put like a little ruler, little paper ruler, and they'll kind of mark the scale of things, whether it be marks or bullet holes or incisions, whatever that may be. They measure that. And the defense argued at some point throughout this testimony that whoever took the photos, they didn't want him testifying to the photos, the crime scene investigator, but he has to testify to them because he took the photos. So he can testify that he took the photos, he can authenticate the photos, but as far as what the photos represent or explaining the injury that is depicted in the photo, that would be more for the qualified expert, who would be the medical examiner or the forensic pathologist in this case. But that's what's going on here.
Yeah, and Your Honor, I simply, so I don't have to get up again.
It will be admitted as states 80 and 81.
Thank you.
Okay. Permission to publish?
Yes.
Was this what you saw on the victim's back?
It is.
Was it what you took a photo of?
It is.
And is that the same thing that you noticed in the victim's back, just different photo?
Yeah, it's just a closer photo.
Court's indulgence.
It's pretty much the nut and bolt of his testimony. I am going to try to go through a short playlist of some of Andy's testimony, which was incredibly frustrating to watch, but you can tell that the prosecutor is really losing his mind here, trying to interview or trying to get testimony out of Andy Chow, who the defense says Rick Chow was defending. The defense claims that Andy and Rick were chasing the victim in this case, Cyrus Carmack-Belton, who's 14 years old. They chased him 130 yards, and then once he fell, Andy tried to say that Cyrus pointed the weapon at him, but he never reported that to authorities when this accident or when this murder happened. Anyways, let's have a listen to some of his interview, and it's pretty frustrating.
But is there any doubt he was trying to get away from you two?
I don't know what he was thinking.
Was he running toward you or away from you?
I was running away from him. Now that he's pointing a gun at
Let me ask you, I'm going to make this real easy for you, step by step.
Okay.
When y'all left the Shell station, was he trying to get away from you two?
I'm not sure why he ran.
Did he ever stop and ask to shake your hand?
No, sir.
Did he ever run towards you?
No, sir.
Okay. He was running away from you, right, Andy?
I can't speak for him.
Was he running towards you?
No, sir.
Was he running away from you? It's not a hard question.
I guess not to me, yes, sir.
He was trying to get away from where you were, correct?
Could be.
It could be. You and your dad are yelling at him and running after him.
I did not. Outside of the store, I did not yell at him.
You yelled at him in the store.
Well, I called out to him, hey.
And your dad yelled to him when he got out of the store.
And my dad called out hey to him, yes.
And he ran away from you.
Okay, yes, sir.
I'm asking you. This is your chance to answer my questions, and they're not hard, are they?
Yes,
He
sir.
ran away from you and your father, did he not?
He did run away from me.
Okay. Thank you.
Okay.
At any point did he turn and engage with you? You understand that word?
He did not.
Okay. When did you start running?
After he ran.
Why? Is there anything wrong with him running?
Well, I ran because I thought he had stolen something, and I wanted to see where he was going.
Okay. How far were you going to chase him, do you think?
I'm not sure. Just going to see where he was going.
A mile? What if he had run a mile? Would you have kept chasing him with your dad?
I'm not sure. I'm not sure what I was doing.
You don't know at what point you stopped chasing a 14-year-old?
I don't know when I would stop.
Who did you tell that day that he pointed a gun at you?
I did not say the exact words, no, sir.
What am I doing right now?
Pointing at me.
Yeah. It's a very simple word, is it not?
Yes, sir.
Okay. You never say pointed. You never use the term aim, did you not? Or you didn't, did you?
I did not. I did motion it, pointing.
Never said point. You never said aim. You said he pulled a gun. I saw a gun.
Yes, sir. I said those things.
Okay. English is your first language, correct?
Yes, sir.
Do you even turn point? You use it all the time, do you not?
Yes, sir.
You understand the word aim, correct?
Yes, sir.
Did anybody stop you from using those words that day?
No, sir. They also did not ask me.
Did you have trouble volunteering that very important piece of information?
The first thing that came to my mind was he pulled it, and then I pointed with my hand.
He pulled. Could it have come out of his pocket when he took that violent fall to the ground?
I believe he took it out.
Could it have come out of his pocket when he took that violent hit on the ground that dislodged the flashlight from his gun?
I'm not sure.
Could it have fallen out of his pocket after you chased him 130 yards and he hit the ground, wounding his shin, dislodging that light from his gun? Could it have come out of his pocket at that point?
It could have.
Okay.
Anything else briefly?
It doesn't happen if Cyrus doesn't pull a gun on you either, correct?
Correct.
Thank you. No further questions.
Anything else?
You don't even know there's a gun if you stay in the gas station!
That's what matters.
Right?
Your Honor.
You don't know he's got a gun if you stay put in the Shell gas station, correct?
Yes, sir.
I'm correct.
Yes, sir.
Thank you.
Anything else briefly?
It doesn't happen if Cyrus doesn't pull a gun on you either.
So very tense interaction there between the prosecutor and the star witness in this case, Andy Chow, who the defense alleges that Mr. Rick Chow was defending when he shot 14-year-old Cyrus Carmack-Belton in the back. So we're going to go back into the courtroom. We are approaching 3 hours now of deliberations. Still haven't seen really any action in the courtroom other than those two questions that the jury had earlier, which were what is malice and what would be murder. So we're going to go back into the courtroom and just hang out.
to see you, Your Honor.
Thanks, sir. All right, Madam Floor Lady, I received your note, and I appreciate the information. And basically, it seemed like an update of sorts. So
Yeah.
what I'm going to ask you all to do is just, and I've shared as much as I could with the lawyers. What you folks do back there is none of any of our business, so I didn't share it all. But I'm going to ask you to continue working. If there's anything we can do to make you more comfortable, snacks, drinks, just let the bailiffs know. And I'm going to ask you to continue your deliberations, and we'll be here if you need us. All right? Any exceptions from the stage?
No, sir.
Sam? No. All right, we'll be at ease again until further notice.
So the first part of the audio there was cut out, but it sounds like the jury's actually hung, and the judge has instructed them to keep deliberating. It is 4:30 in South Carolina, so it's not the end of the day. Even if it was, the judge would send them back into the deliberations to continue on. So we'll keep an eye on the courtroom. You know, this case is, somebody asked earlier in the chat, what is everybody thinking? And, it's very undecided, I think, in a lot of directions on not what I would do or what you would do, but what a jury would do. People that we don't even know. Now, we do know that the jury is made up of 7 men and 5 women. That's really all that I know about the jury. And, the penalty Rick Chow is charged with murder, so the penalty for that is a mandatory minimum term of imprisonment of 30 years to life in South Carolina. So that's a lot of responsibility to give, 12 people to decide with what we've seen in this case. I mean, a lot of times, we see trials go on for 2 and 3 and 5 and 6 weeks, and there is a lot of clutter evidence in a case or circumstantial evidence in a case. This case doesn't really have a ton of evidence. There's a few videos, which I think they probably could get through in probably 30, 45 minutes. Even if they watched them, a couple times and, replayed them. And then the charging instructions, the indictment. But there's not a lot of review for them to do as far as evidence goes. Only one victim in this case, only one defendant in this case. Pretty cut and dry. I think if they are hung and they're still deliberating 3 hours and 23 minutes later, that it's possible that they actually are having a lot of conversation, a lot of back and forth, and a lot of, trying to sway each other to be on the same page to deliver a verdict in this case. So we'll keep an eye on the courtroom, and we'll let you know if they have any other questions. We're not controlling the courtroom audio. So when I have it in the courtroom and the courtroom is quiet, that is being controlled from the feed. But when there is audio, you'll be able to hear that. So that's why we're keeping it on that feed live. We have the jury clock ticking there, 3 hours, 23 minutes, and 47 seconds. So we'll continue on and see if we get a verdict today.
Were you able to determine the cause of death?
So it is just after 5 o'clock there on the East Coast. The jury's been deliberating for a little over 4 hours, just hit that 4 hour mark. They had two questions. Their question earlier was, what constitutes malice and what is murder, or what could make Rick Chow guilty of murder? The judge explaining away malice, that you must have either malice or forethought, and that malice doesn't have to be weeks or months ahead of time. It could just be right then. But very quickly, he kind of got over the part that malice is not required to convict someone of murder in the beforehand. But in that moment, you would need malice or forethought. I'm sure you've seen in other cases where just the motion, basically, of pulling out a gun to shoot somebody is forethought. So, but it's up to the jury to interpret that, and that their verdict will be based on their interpretation of the evidence. The judge is there just to basically lay down the law and tell them how to use the evidence to then correlate to the law to reach a verdict. And then the jury came out about, I don't know, maybe 30, 40 minutes ago, and I think they were hung. The judge forcing them back into deliberations. And now we are, like I said, a little after the 5 o'clock mark. So we're going to keep an eye on the courtroom. At some point, I would suspect the judge will ask the bailiff to just check in with the jurors and see where they are, what's going on, how they're feeling, if they're close. Not to rush them, but to just kind of gauge them. We may have a verdict later today. It could be hung. It could be guilty. It could be not guilty. Let's see. We're at 90% guilty in our poll, 4% not guilty, and 6% undecided. And as I mentioned earlier, there's not a ton of evidence for the jurors to go over as far as exhibits back in that jury room. But, if you have somebody or more than one person that is on a different side, then you kind of have to negotiate with each other. And, I find usually jurors take their job very seriously, no matter their age, no matter their seriousness. The job of performing jury duty in the setting of the courthouse with the bailiff in this private room with lunches being catered, things like that, they do take it very seriously. But, throughout the whole trial, they're just listening like you and I. And they don't know what to do with that information until they're charged. They weren't charged until today, but heard the evidence through the end of last week. So they had the weekend to just kind of go over this stuff in their head, or dissect it, think about parts of it a little more. Weighing on their conscience is the future of Rick Chow, who faces 30 years to life imprisonment in the South Carolina Department of Corrections if convicted of murdering 14-year-old Cyrus Carmack-Belton. So we're going to keep an eye on this courtroom. I do expect to have some sort of an update soon, whether it be check in with them, see where they are, or a verdict or a hung jury, but we shall see. So stay tuned, and we'll keep it right here. All right, going back into the courtroom for a moment. I do believe I did see a little bit of movement in the courtroom, and now we're getting some audio feed interrupted. So I think we're going back in. Let's see what's going on. And we see them bringing Mr. Chow back into the courtroom, handcuffed and shackled, I do believe. All right, so I'm going to pause our jury clock. And we're at 4 hours, 32 minutes, and 42 seconds. And looks like we're just waiting on prosecutors and defense attorneys to get back into the courtroom. And I'm not sure yet if we have a verdict or if we're pausing until tomorrow so that the jury can continue deliberations. We'll find out here shortly. Let's wait on court to be back in session. Only Discord, you never really can tell. I've seen juries deliberate for more than a day. I've seen a jury deliberate for an hour and maybe an hour and a half. They say a fast jury is a guilty verdict. So when jurors are taking a longer time to deliberate, that typically means that they're, still thinking about it or still working through it. I would not say that 4.5 hours is a fast verdict. I wouldn't say it's a slow verdict. It just depends on how much evidence and how many exhibits they have to go through. Most of the testimony and things like that, they have to just remember unless they're allowed to take notes. In this trial, they were not allowed to take notes, so they had to just keep everything in their head. But the exhibits, such as the videos and things like that were played and shown, and the photographs, those will go back to the jury, and they can look at those and review those. And so sometimes that takes a while. But really, you can't really gauge how long it's going to take for a jury to deliberate a verdict. And then, if there's somebody that's on the other side of the fence, then they try to kind of negotiate and think through the facts. Remember, it's up to the jury to decide the facts, and then it's up to the judge to tell them how to use those facts to get a verdict and associate it with the law. So yeah, 4.5 hours. I don't think it's that long. I think it's probably a little bit longer than I expected for the little bit of evidence, that they went through. I will say the defense did not put up a lot of evidence. I think all the evidence that we saw was from the prosecution, except the defense did call the one witness who was a police officer. They may have wanted to review that footage again and compare it to the police officer that the lead investigator that the state put up. I did think it was interesting that the defense offered a law enforcement officer as a witness for the defense that the state did not call on. That was a Lancaster Police Department officer who was dispatched to the scene as backup, but his body camera footage captured some conversations with Andy Chow that the state left out of their body cam footage. So, but I didn't think it actually helped the defense to show that footage. I thought it actually helped kind of nail down what the prosecution was laying. And in fact, Andy, I don't think he said that he pointed the gun at him. I think he said he saw a gun, which has been consistent all throughout the trial, witness testimony, and the body cam footage. Never did he say that it was pointed towards him. I believe there's one point in this trial in Andy's testimony on the stand where of course now he's saying that the gun was pointed at him, but I think there was one point on the stand where he said that he could see the inside of the barrel. And the prosecution saying today, the inside of that barrel is black, and he would not have been able to see inside of that barrel. So Rick Chow sitting here, and I've seen him in kind of this deep meditative, I don't know if he's praying, I don't know if he's meditating, but he's centering in, and he's certainly hopeful that he will either have a hung jury or a not guilty. I'm certain that's what he's doing right now, is really focusing his meditative energy to summon a not guilty verdict from 12 of his peers who have just deliberated for 4.5 hours over his guilt. Now, if convicted, Rick Chow could face minimum 30 years to life imprisonment in the South Carolina Department of Corrections. He would first be transported to the reception facility there in South Carolina, where they would shave his head, photograph him, get him into the system. He would have all sorts of diagnostics and checkups, and then he would be transferred probably to a facility nearest his relatives, which probably would not be far from that reception facility, which I think, let me see if I've got that. Yeah, Lee, I'm not exactly sure, but yeah, he would be there to start. So the courtroom, just waiting on the rest of the defense team and prosecution team to get back into the courtroom before we find out what is going on with the jury. Maybe it's just the end of the day. Maybe they're just going to resume again tomorrow and sleep on it. That may be a good decision, but they won't have each other to confer with if that's the case. But we'll just wait and see. What do you guys think? Tell me in the chat. Do you think it's going to be a guilty verdict? Do you think it's going to be a hung jury? I've also been looking at some other chats for other channels that are covering this, and a lot of people are saying that they think it's going to be a hung jury. And, I just didn't saw the victim hold a gun. I'm not sure what you're trying to say there, but they said the victim did have a gun, but because somebody has a gun doesn't necessarily mean that you can shoot them. Does that make them an imminent threat? Do they have a duty to retreat? Also, the prosecution laid out this morning in their closing arguments that there are 4 elements to the law of defense of others. And that's what the defense team is claiming here, that Andy Chow had a gun pointed on him and Rick Chow had to shoot and kill Cyrus Carmack-Belton, or he would have killed Andy. But there's 4 things that they must prove to use the law of the defense of others. And if any one of those things, all it takes is one of those things not being proven for that theory to be thrown out. And the first one must be without fault for bringing on the difficulty. And the prosecution team said he failed right there by chasing him and then continuing to chase him after he fell, got back up, continued to run, and then fell again. And then we did see those pretty substantial injuries to his legs, to his right leg, his shin there where he fell. Pretty rough fall. And then the other 3 elements to the 4 elements of the law of defense is belief in imminent danger, a reasonably prudent person, and then duty to retreat. And then malice and forethought. You know, the jury came back, they had questions about malice and forethought. They also wanted to know what would constitute murder here. The judge really dissecting the malice and forethought, just reading the law to them, kind of skipping over the murder part a little bit, didn't focus too heavily on that. And then, of course, we saw that video of that, the exact path that Cyrus took and that they chased him through. And I will say, it's further than I thought. Even, you know, discussing 130 yards, we've heard that many, many times throughout the case. But actually looking at this path, and I can still see the courtroom, by the way, but I'm going to put this up just... This is the entire path. So out of the front door of the convenience store, and then across the parking lot. So you're looking at how far they chased him from the convenience store. Court is back in session.
All right, counsel, just so we're clear on the record, we gathered in the chambers. We let y'all know that we received another note, which I believe also contains some of the deliberative process of the jury, which I'm not comfortable disclosing within, are basically consistent with South Carolina law. It's not. So I'm going to, and I can say, mention that at least some had indicated they may want to go home for the night. I'm not inclined to do that. This case has garnered a significant amount of media attention. I would be concerned that the jury could somehow be compromised or research or something. So now that we've started the process, I'm going to ask them to push on through and go ahead and order dinner. Any objection to that from the state?
No. No, we concur.
Okay. All right, bring them in, please, sir. Yes, sir. I have received your note. I understand some folks may be getting fatigued. This has been a long day, long week. Typically, once the deliberative process begins, we ask you to stay here as long as possible. Certainly, we're not going to do anything inhumane. But I'm going to ask you to keep deliberating. The clerk is going to get with you shortly with regard to orders for dinner. And we're just going to ask you to keep working. I understand it's been a long day. It's been a long day for everybody. And I I know y'all are diligently working, and I appreciate that. But we're going to ask you just to keep working, and we'll get your dinner orders, and we'll just let us know if you need anything else. All right, thank you.
You hear the forelady there answering okay as the judge sends the jury back into the jury room to continue deliberations.
All right, thank y'all. We'll let you know. Yes, sir.
All right, so I started our jury clock back, so we're at 4 hours, 32 minutes, and 54 seconds and counting. So, you know, like the judge said, they do not typically like to break up that deliberation process. Once it starts, they like to keep it going. So the judge is going to order them dinner and send them back to the jury room to continue their deliberations, forcing them to keep trying to deliver a verdict in this case. We know earlier that the jury was hung, and then the judge, you know, had clarified a couple details for them, but sent them back to deliberate. That was at least a couple hours ago. So they've had a little more time now to kind of work through any problems that they've had, and they still, at 5:56 p.m. Eastern, they still have not reached a unanimous verdict in this case. They have not announced that they're hung, though. They are still working. So the judge sending them back into chambers to continue their deliberations. Hopefully they will be able to come up with a verdict today. I know this family has been in the courtroom 3A there in Richland County all last week. They've waited 3 years for justice in this case. You know, Cyrus was killed on Thursday, marked 3 years, and the family spent Thursday there in that courtroom. Anytime you have a child fatality, you know, the emotions are high. But in this case, there was public comment, and there were press conferences, and there was a lot of media. So the public is very on edge, and the community has very much been in defense of this case and this family. And sometimes that's what it takes to get these cases through the system. I've been reading a lot of comments, and it's house divided. You know, a lot of people feel like the Chows had every right to defend themselves when the gun was pointed at them. But I would challenge that to say, if the gun was pointed at them, we don't have anybody saying that outside of the Chows. And of course they're going to say that. Not saying they're guilty, not saying they're innocent. That is obviously for a jury to decide. But when you're looking at the evidence and you have witnesses saying, as I approached, I didn't see him shoot him, but I saw him in a standing position over him, as if he was shooting. And then, you know, they admit that they shot him, but the defense, or that Rick Chow shot him, but the defense argues that he shot him in self-defense. But there's nothing corroborating that. So it's going to be an interesting case. We're just going to have to wait and see. And I agree, Doris, he should go to jail, period. And by the way, I mean, there's a lot of stuff that we're not aware of when we're just watching this trial. There have been, I think, over 140 instances where police have been called to the store for like minor shoplifting. But there are other videos that have surfaced from community members where the Chows have been engaged in physical altercations with underage minors. It's just, you know, over a candy bar, over an icy, over a bottle of water, which, for the record, again, Cyrus did not steal anything. You know, many people in the chats are arguing, well, why was he in this store with no gun, with no money, and he had a gun? Yes, he had a gun. No, he was not old enough to hold a gun. No, he did not have a concealed weapons permit. He was 14 years old. He was totally wrong for having a gun, but nobody knew he had a gun. Nobody knew. Nobody knew until they chased him 130 yards. I was playing the video earlier of how far that route was that they chased him, and we didn't get to finish it, so I'm going to play it again. And somebody asked earlier, why are we playing things from the trial? Because we have nothing else to do. The jury is deliberating, and we are just sitting here in dead silence. So why not? And not everybody has seen every minute of this trial. So I think this definitely stood out to me. I mean, I had seen other video clips of him running and them chasing and, you know, the cars pulling in, but we didn't actually see like a virtual tour as if we walked that route ourselves. And here it is. Now, by this time, Cyrus had just ran out of his shoe. He's coming down this path, and then he crosses the road, a 2-lane road there that dead ends. And at the end of this road, or further down this road, there's 2 apartment complexes. It seems like they kind of share the same property, but I think they have 2 different names. So I think it's 2 different complexes that kind of are next to each other. And I thought that they stopped like in that first area right here. Here's where he goes. He goes all the way down through here, and this is where Cyrus falls for the second time. And this would be where he took his final breath. So, I don't know, I just thought that was really interesting to see how far it was. I mean, when they asked Andy, how far were you going to chase him? He said, I don't know. I was just chasing him. Just gonna keep chasing him forever. I guess if his dad wasn't on trial today, I guess he'd still be chasing Cyrus, right? All right, so we're watching the courtroom. We have our eyes peeled. We're at 4 hours and 39 minutes of deliberations. Dinner is on the way to the courthouse for the jurors. The judge has forced them back into the jury room. So I do expect a verdict today, especially with Judge Taylor asking them to continue their deliberations and not letting them pause. That's going to force somebody to overturn just to go along with the rest of the group. Probably, possibly. We shall see. All right, stay tuned. We'll keep our eyes peeled here on the courtroom, and we'll see if they come back. Hey guys, some of our streams may go down because we are reaching that 8-hour mark. If they do, just refresh or come right back. If they do go down, we'll bring them right back. The jury clock will continue. The production will continue. We'll just need to reset the streams. So just in case that happens, you'll know what to do. Jury deliberations are still underway outside courtroom 3A in Richland County, South Carolina, as the family of 14-year-old Cyrus Carmack-Belton still are joined there at the courthouse praying for long-awaited justice in this case. 3 years has taken this case to get to court, and previous to this trial, which jurors probably don't know about, there was a stand your ground hearing. So the defense felt like this was a stand your ground case. They had a hearing after making a motion to the court, and the court denying that this met the criteria for a stand your ground, and sitting it to trial, which is where we are now. After 4 days of testimony and closing arguments today, the jury started deliberating about 5.5 hours ago. They at first had two questions. What constitutes malice, and then what would Rick Chow have to do to be convicted of murder? The judge explaining the malice aforethought to them, sending them back to deliberate. Then they, I guess, indicated that they were hung, and the judge said, no, go back and continue deliberations. Then they came back about 45 minutes to an hour ago and said, we want to go home. We want to kind of call it a day. We still have not reached a verdict. And the judge said, absolutely not. Once deliberations start, we want to see them through. We don't want to take a break in the middle. I'll order you guys dinner, but please go back into that jury room and continue your deliberations. So as it's approaching the 7 o'clock hour there in South Carolina, the jury is still deliberating this case. Now, Rick Chow, he was a former convenience store owner accused of chasing 14-year-old Cyrus Carmack-Belton over 130 yards. And, in that video, we see Cyrus coming out of his shoes before the teen dropped his book bag and then fell again, or fell a little while later. And then Andy Chow says that he pointed and presented a firearm at him, but no witnesses saw that. Andy Chow did not report that to authorities on scene when he was questioned. We've seen body camera footage throughout this trial from a couple different angles, and we heard from that forensic pathologist from the Medical University of South Carolina that Cyrus Carmack-Belton was shot in his back, and there was a bit of an angle because it penetrated his lung and then the right part of his heart, essentially causing him to hemorrhage there on scene. We saw a lady that performed CPR and tried to stay with him. We heard from the lead investigator. We heard from another investigator that the defense actually put up. That was from a Lancaster Police Department officer who had just another body cam vantage that we were able to see. But, the facts of the case are pretty tight and narrow. At points during Andy Chow's testimony, it was very difficult for the defense, or for the prosecution, to get answers out of him. Even at one point, they were screaming at him. So it's been a very tense trial. There's been a lot of community engagement over this trial as well. There's been a lot of publicity, but there's been public officials that have spoken about this case publicly, and that was reason for concern. I think the defense filed a motion right before trial asking to change the venue because the coroner had made some public comments, as well as Sheriff Leon Lott there in Richland County. Now, some people have asked about maybe a lesser charge. The defense team chose to take that off the table. So they're just deliberating murder, and there is no lesser to choose from. So manslaughter or anything like that is just not on the table. The jury will have to convict him of murder or not. And then a lot of people too were asking about the evidence. Why is the lab the police department? Well, Richland County in South Carolina has its own lab, and they do their own stuff. They don't set it off. They don't use, and in a lot of other trials in South Carolina, you'll see the South Carolina Law Enforcement Division, also known as SLED, testifying to evidence, especially like in the Murdaugh trial, things like that. Trials like that, you've seen SLED. In this trial, it is Richland County, and they have their own lab. So they testify to their own evidence. They put up their own experts, and that's what we've seen consistently in this trial. The defense team is one heck of a team. that is probably the most expensive defense team money could buy in South Carolina. We see some familiar faces there from the Murdaugh trial, as well as Sean Kent, who is just a beast in the courtroom. I was just telling someone earlier, as a defense attorney, I'm always hoping for justice for the victim. So, as a defense attorney, I can't stand Sean Kent. He's very abrupt in the courtroom. But with that being said, if I was on trial for murder, I think I would hire him first. If I could afford to, I would definitely call him first. He is an astounding attorney, very talented, and he's very funny. If you watch his TikToks and Facebook, things like that, if you follow him on social media, there's a very humorous side to him. But in the courtroom, he is very abrupt, and I've seen in some of our chats, some of other chats, his delivery is not well received by viewers. He's very tense, but he's a very good attorney. This team that Chow has, they're all great attorneys. So we've seen Chow in like some sort of deep meditation. I put some pictures on our X earlier under the video for today, of him with his eyes closed in the courtroom. I'm not sure if he's meditating, if he's praying, what exactly is going on, but he certainly is in deep trance on, these deliberations. They say that a short verdict, a quick verdict, is usually a guilty verdict. So the fact that they've been deliberating for 5 hours and 31 minutes, 31 minutes, just never know. You never can tell how long it's going to take a jury. I don't think there was a ton of evidence in this case for them to review, even if they reviewed it over and over. If they looked at a video and played it over and over for a few minutes, I don't think it would have taken all this time. I think the time is mostly spent on conversation and them trying to come to an agreement for a unanimous verdict. So we're going to keep our eyes peeled on the courtroom. The judge forcing them back into deliberations after just 4 days of trial. The prosecution earlier, talked a lot about those 4 elements of the law when it comes to the defense of others. There's another case in South Carolina that is on appeal right now on a murder conviction that was for the defense of others, and it'll be interesting to see how that plays out as well. But for this one, the prosecution said that 4 things must all be checked. If one of these things is unchecked, then the whole defense of others defense is out the window. And the first thing on that list was must be without fault for bringing on the difficulty. Whose fault was it that they ended up 130 yards off of their property, far off of their property? In fact, since we're doing nothing else, I'm going to show the path again. This is a path that they took out of the store. So this is leaving the front of the store. Cyrus rounded this corner to the right and then immediately back to the left because that's when the Chows came out and started chasing him. And about right here is where you saw the shoe fly off. And he continues down this little path. And at some point he shed his phone and his book bag. Not sure if it was on that side of the path or, well, the book bag we know was over here. Not sure where the phone was dropped. He continues on, and I was shocked at just how far. And I thought at this first little alcove here was where he fell and was shot, but I was wrong. It continued even further on into this little kind of gravelly kind of area and down through here. And that is where Cyrus took his last breath. That is where Rick Chow shot him in the back and killed him. And this case also had a stand your ground hearing before it went to trial. And the judge determined it does not meet the criteria for stand your ground in South Carolina and sent the case to trial, which we're on day 4 of. So we're just going to stay peeled to the courtroom and see what the jury does here. We're at 5 hours and 34 minutes, so stay tuned. If the feed does go down because we've been on for too long, just sit tight. We'll come right back up. You may have to refresh or rejoin, but we will bring the feed up if it goes down. So stay tuned. Are they scoffing at us? I can't really tell. Seems like they're scoffing at us. This is Alice Chow and supporters, people that came with her to support Rick Chow. Not sure what's going on, but I did stop the jury clock. I do believe either the jury is going home for the day, or they're hung, or they have a verdict. I don't know. We'll just have to see. But we're standing by here and being scoffed at, it feels like, from the supporters of the Rick Chow family.
Glad we have everyone. I have another note to mark as Court's Exhibit 23. Says, Judge, we request to hear your entire instructions to the jury. So they want to be completely recharged. I don't know if I'll ask if they want to hear about, the part about their duties and my duties and all that. Maybe where some of that's only a page. So I'll confirm with the foreperson that they want everything. And if so, we'll completely recharge.
Your Honor, we had earlier discussed with the prosecution allowing them written instructions. I would now request that on behalf of the defense, instead of your reading them to them, send it back to them.
What's the state's position on that? Well, I think I have the discretion to do that, and I can tell you I've never done it. My concern, and I do, like I said earlier, maybe during the charge conference, I have some of my colleagues that do it. My concern is it's all supposed to be considered as a whole, and Mr. McCullough might like really what's on page 12, and Mr. Scott might like what's on page 16, and Mr. Swerve might like what's on page 24, and not going to look at the rest of it. That's the only concern I have with it. They have well, if y'all are okay with it, I'll consider doing it.
Whatever you say.
They specifically asked for you to read it to them. I don't know if they knew they had an option.
I'm happy to work this out however y'all, I can ask them if they think it would be helpful if they had a copy.
I think we'd be fine with that. That would help them.
My only concern, and it always was as a practitioner, that somebody zeroes in on one particular word instead of reading, the comprehensive charge. But I'm happy to entertain it and be convinced otherwise. No, about it.
No, I don't have anything to say about it. Your side.
So the jury is asking the judge to go back through the jury's asking the judge to go back through the charging instructions. Those charging instructions are very long and they're complex and they're pretty fast. They're a steady motion.
Of caution, maybe bring the foreperson out and ask what her preference would be. Or if she wants us to bring out, read the whole thing if they want a section, or I can give you a copy and send it back, and let that be the foreperson's preference. I think all sides would agree that that would be the best way to handle it. Maybe
Everybody agree
bring
with
it out
that?
here, the whole red, whatever.
That's what the state agrees to that.
Okay. All right.
What do you guys think?
All right, can you please bring me the floor labels? Hello.
Hello.
All right. Now I'm going to ask you a few questions, and I want to make sure you understand. I don't want to know about anything going on back there.
Okay.
How people are voting, what they're thinking,
Okay.
who's tired. That is not anybody in this courtroom's problem. Okay. So we're clear on that. Your note says that you requested to hear the entire instructions again. Both sides, the state and defense, have asked that I inquire, number one, do you think you need all of it, or are there specific sections? And number two, do you think it would be, in lieu of that, be beneficial to have a copy of it for you all to review? And
We would love a copy. We thought we couldn't request a copy of it. Yes, we would much rather have a copy of it. We've been saying that for a long time. Yeah.
Okay.
So that would be great. I thought that was one of the stipulations, is that we couldn't
Well,
have a written copy of it.
typically, my practice is that for various reasons, but the parties both suggested this and appear to have agreed to it. So I'm certainly willing to let the lawyers do their thing and make their decisions. So, all right, is everybody comfortable with sitting back to top?
Your Honor, we're just not sure whether we should send 1 or 12.
I think a couple of copies would be fine.
Okay.
Mm-hmm.
All right. We will do that for you. You can do that. If you want to head on back to the jury room, we'll get 3 or 4 copies
Okay.
made.
That's perfect.
And,
Thank you so much.
Keep working.
Okay, we are.
Dinner
Thank you,
should
sir.
be here shortly.
Okay, thank you.
All right, thank you.
Mhm.
Yeah, I had underlined. I had underlined the page where we were making some changes, or I think it was where something y'all wanted included, it wasn't, or something I had changed, and I don't remember thinking, I think page 18.
Not as long as it's a clean copy, we're good. 2 clean copies.
Could I just suggest as few as possible, because I think the more that are out there, that wouldn't foster as much group deliberation.
Well, let's do 3.
3 total?
Yep. You sure that was clean? It had no mark?
I think I'll watch it as it slowly goes through the feed, but it looks clean.
I did not want to.
Yeah, I had marked that page because I knew there was going to be some discussion. I don't want to see something I underline and think is more important than the rest of the charge.
Can we go on record about one matter, Your Honor?
Yes, sir.
And this is, and I think it still counts as contemporaneous, but we need to make sure when the solicitor was giving their rebuttal closing, I made an objection. And I don't think we ever covered or put that on the record. I think I contemporaneously to the solicitor mentioning pay apps on the phone specifically said, I think perhaps I should have gotten an expert. At that point in time, I made an objection. I asked to approach the bench. At the bench, I made an objection that there were, 1, no facts in the evidence that would suggest that there was a pay app on the young man's phone. Number 2, I stated that the witness on the stand was specifically asked about pay functions of the phone. And number 3 was very specific that there is no evidence whatsoever that has been turned over in discovery. As a matter of fact, I think this phone has gone through a cell-bright analysis that there would have been nothing that would have shown that he would have had payability on the phone whatsoever. So at that point in time, I said that objection would have been. The analysis of the solicitor when he was making his closing argument, I said was impermissible at that time because he was putting facts that were not in evidence, not supported by any facts, and the solicitor would have had knowledge that there were no pay apps on the phone. And I made that objection contemporaneously. I just don't think I put it on the record.
Well, it would have been captured at.
I don't know if it was captured, but I just wanted to make sure.
Okay, well, I'll note that, and that I was overruled your objection. I felt like the solicitor was arguing that there could have been, not there was, kind of thing. So but I'll note your objection.
Thank you, sir.
Maybe a slow sprinter.
We don't allow this. Take a safer ride to it.
There's one right here. Can you make sure we get all 25 pages?
Numbered 1 through 27. Yeah, they're all in. And all the way through.
Yep, we're gonna need to stop copy. We're gonna need to
Copy
redact.
was done.
Like on 15, it notes, trial court shall not, and these are footnotes that have just been inserted. The trial court shall not instruct the jury that malice may be inferred from the use of a deadly weapon, Simon State versus Burnett, and then noting some matters appropriate for jury argument are not proper for charging.
We need scissors.
Yes.
Or white out Sharpie or white out.
I'd say scissors.
We can cut. Yeah. Scissors? Get rid of it completely?
Or if you wipe one out and then just make another copy of page 15?
There are several.
Several?
Yeah, you just need a significant number of whiteout.
Permission to cut off all the footnotes?
Yep.
Okay. I'll deny us. So we're- That one's done. At this point, this will be faster.
sir.
All right, we'll keep deliberating.
6 hours of deliberation at this point. I mean, it's approaching the 8 o'clock hour there in South Carolina, where Judge Heath Taylor has sent the jury back to deliberate even more. So jury broke around 12:30, 12:45 today to begin their deliberations in this case, and they have been deliberating ever since. They first came back with two questions. One was, what is malice? And the second question, and here we see on screen the family of Cyrus Carmack-Belton, who has been in the courtroom every day. Just cannot imagine what they're going through, just the agony. And today, the final moment of this verdict taking so long. And then to already have waited 3 years, and to top all of that off, Thursday was the 3-year anniversary, May 28th, since Cyrus was murdered. Rick Chow, every time they're coming back into the courtroom, they're removing him in his handcuffs, and then he's taken out. The family of Rick Chow, which is, I guess, Alice Chow, they're in the courtroom with a couple of what looks to be like her friends accompanying, kind of scowling at court TV cameras there in the courtroom. Just in this moment of tension there in the courthouse, and they have to keep coming back. So jurors wanted to know, what is malice aforethought in South Carolina? And this is the technical definition. In South Carolina, malice aforethought is a legal concept central to homicide offenses, particularly murder. It refers to the mental state of the defendant at the time of the act, either express malice, which is a conscious intent to kill, or implied malice, which is intent to cause death or great bodily injury. And then the legal definition of the differences of express malice are highlighted below, and that is the indictment 16-3-10, murder, which is what Rick Chow is charged with. Now, I mean, closing arguments today, I didn't feel like the state's lead prosecutor in this case really humanized Cyrus in the closing arguments. Well, then, when the defense got it, Sean Kent did the closings, and in his normal style, he had the attention of everyone in the courtroom. And then Byron Gibson, which is the Fifth Circuit solicitor there in South Carolina that's prosecuting this case, he rebutted the closing, or did the final closing, and he very much humanized Cyrus. And I thought the state did a good job in that final moment. They also showed the path that Cyrus traveled, and I'm not sure if everybody has seen that. We have it here. I'm going to play it for you. Some of you have already seen it. But this is a path. When you walk out of the store, Cyrus walked out, he turned this corner, and then he noticed that they were after him, and that's when he took off. You see one shoe fly off at about here, and then he goes on down through this path. And I knew that once they crossed the street that the Chows continued to follow him. I just wasn't equivalating exactly how far without this visual. And then they continue to follow. They're chasing him. He falls down, suffers a pretty bad leg injury, gets back up, continues running, and the Chows chasing behind him, Andy and Rick Chow. This is where they kind of curve in, and that is when Cyrus fell the second time, and Andy Chow said to his dad, he's got a gun, and Rick Chow shot him in the back, and Cyrus died there on the scene. Those who rendered aid to him testified in this trial. The lead investigator, the coroner, as well as the sheriff of Richland County, also made public comments, leading up to the trial. And there's been a lot of support in the community for this family and justice for Cyrus. So, the jury had those two questions early today. The judge explained malice to them. Then they came back, and they were wanting to basically throw in the towel. They said that they were hung. The judge said, absolutely not, go back, continue deliberations. Then they came back even maybe an hour, 2 hours later and said that they wanted to go home for the day. The judge said, no, if you're hungry, I will order you dinner, but go back and continue deliberations. We do not want to stop deliberations once they start. And then, to ask, Shannon just asked, does anybody think Chow has a chance to walk? It's possible. I think we got a report that there were 7 men and 5 women on this jury. I've not confirmed that, but that's what someone said in the chat. So I take that at its value. But you just don't know. You don't know how these are going to play out. So we're going to continue to watch this courtroom, and we'll be bringing you back if they have any other questions or any other dilemmas. I will say I am this juror. I would need, those charging instructions can be extremely complicated, and not only complicated, but they're very fast, and it's a lot of information. So you sit through a trial for a whole week, and then all of a sudden you don't know what to do with all the information that you've just heard until you get those charging instructions, and it all comes at once. So, the jury requesting a copy of that, and then, of course, they said, well, we'll send a couple back. They said 2 or 3 or 4, whatever. They settled at 3. So 3 copies just went back to the jury. There are 12 jurors. So now that they have those instructions in front of them on paper, they're continuing deliberations into the 8 o'clock hour after 6 hours of being behind that juror door. So, we'll just have to wait and see. But the judge continuing to pressure them on for a verdict in South Carolina versus Rick Chow. Stay tuned. Action now back in that courtroom in South Carolina versus Rick Chow. Let's tune in and see what's going on. I'm going to stop the jury clock and we'll tune into the courtroom. There's no sound coming from the courtroom currently, but as the defense team fills the courtroom and onlookers, the sound will come back. There it is. I mean, 7 hours into deliberations. Court's actually been going on more than 11 hours today, since they started at 9:30 Eastern this morning. It's approaching 9. Well, it's 8:36 Eastern, so it is late into the day. The jury asked way earlier this afternoon, around 5:30, if they could go home, and the judge said no. Please deliberate until you reach a verdict. Ordered them dinner. And they are still there. So they did come back a little while earlier and ask for a copy of those charging instructions. Charging instructions are after the jury hears all of the evidence. The charging instructions are what they're to do with that information and how they're to apply that to the law. The problem with the charging instructions, and I completely agree with jurors when they need copies of these instructions because they can be very complex. They're long and they're given very quickly. Not a lot of time to process everything in that. So when you're talking about malice and malice aforethought and intent and considerations basically within the law and how to apply all of that, I think it helps to have that information in front of you. But the jurors clearly having a hard time today. They broke for lunch from 12:30 to 1:30 or so, ate lunch there at the courthouse, and then we're in deliberations until now. We're breaking again. I'm assuming we got a little bit of sound. Everybody's still gathered there in the courtroom. I don't know that we should have stopped the clock. I guess we'll find out. But yeah, so we're just tuned into this and we'll see if they gather in the courtroom. They have to go get everybody. Every time the jurors have a question or every time, there's an issue where the jurors need to reach out to the court has to gather because everything has to be done in front of the prosecution and in front of the defense. And then you'll see Mr. Chow, this is Rick Chow, being led into the courtroom again in handcuffs. This is about the 5th or 6th time during deliberations today that he's been cuffed and drug into the courtroom. You'll see Alice Chow is there. She has about 3 friends with her that we've seen kind of scoffing and scowling at the court TV cameras there in the courtroom. Mr. Chow seeming rather rather calm. He has kind of been meditating or praying throughout the day. We've seen him kind of close his eyes and focus, and you can tell he's reaching deep into personal reflection here into 7 hours of deliberations. And this really, his fate is in the hands of this jury. The penalty for murder in South Carolina is 30 years to life imprisonment. And so, he's facing a lot here. He's already been in jail for 3 years. But the reality is he's alive and Cyrus is not. I really, while we've been waiting and this clock has been ticking throughout the day, I've just thought many times why we are all here. why the jury is taking this long. I'm glad that they are. I'm glad that they're really considering everything, and I hope that they're considering the weight of the burden of this verdict on the victim's family, who will never have a future because his life was taken. But yeah, let's hope the jury gets it right. We're going to tune in here. I do see more defense coming, so I do think stopping the jury clock was probably a good idea. We're not going to have sound out of the courtroom until everybody gathers and they get on the record, but stand by, and it'll just be quiet for a minute, and we'll see what's going on. This is Alice Chow coming into the courtroom there, and yeah, it looks like others are gathered there on that side. Let me see, more defense team gathering and coming on board here. Looks like the prosecution is there. Victim liaison is there on the prosecution side. Victim advocate. Some of these attorneys, they don't move so fast, do they? But they are all piling into the courtroom. Where are you guys watching from? Tell us where you're watching from. If you've been watching the other days of the trial, or if you're just tuning in to deliberations. Trial's gone on for like 4 days. Today is day 4. Here we go.
All right, I understand, ladies and gentlemen, we have a verdict. Again, as I cautioned everybody earlier, there aren't going to be any outbursts, anything of that nature. If so, you'll be removed from the courtroom. Like I said earlier, I appreciate everyone being respectful throughout the past week of one another, even though there are a lot of emotions in this case, and everybody sits at 2 very diametrically opposed views on this case. But again, not going to have any outbursts, anything of that nature. If so, you'll be removed. All right, bring us the jury, please.
Yes, sir.
Seated, Your Honor. All right, man, poor lady, I understand you've reached the verdict.
Yes, Your Honor, we have.
Can you please hand it to the bailiff there? All right, Madam Clerk, will you please publish?
Yes, sir, Your Honor.
Indictment number 2023-GS40-07440. State of South Carolina, County of Richland versus Chike Rick Chow. We, the jury, unanimously find the defendant, Chike Rick Chow, as to the charge of murder, not guilty. Signed number 302, foreperson, June the 1st, 2026. Madam Forelady, was this your verdict and the verdict of the entire jury?
Yes, ma'am, it was.
Thank you.
And from the state.
Would you like to poll the jury on?
Madam Forelady and ladies and gentlemen of the jury, I'm going to ask you 2 questions relating to your verdict. Please answer yes or no to each. Number 302, was this your verdict?
Yes, it was.
Is it still your verdict?
Yes, it is.
Number 2, was this your verdict? 257?
Yes.
Is it still your verdict?
Yes.
Number 63, was this your verdict? Is it still your verdict?
Yes.
Number 208, was this your verdict? 208. Is it still your verdict? Number 226, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 329, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 222, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 164, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 21, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 204, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 232, was this your verdict?
Yes.
Is it still your verdict?
Yes.
Number 259, was this your verdict?
Yes.
Is it still your verdict?
Yes.
The jury's been told, Your Honor.
Very good. Anything else?
Not at this time, Your Honor. We just like staff post-trial motions, normal 10 days if we feel those are.
10 days for any post-trial motions you may have, anything from the defense? Okay.
Look it over, Your Honor.
Okay. Ladies and gentlemen, you can return to your jury room. I'll be right back there to excuse you.
With regard to thank the jury.
All right. Well, we are adjourned. Thank you, Your Honor.
You know, there is something about the cry of a mother that hard to swallow. So, not guilty for Rick Chow. And, yeah. Case over for now. Case over for his family. But the gasps and his mother crying out in court, and then just what they've endured in the 3 years, and last week and this week at trial, and then every single day that passes after today that they think of him should have been there. We heard his mother say in a, I think it was a bond hearing, preliminary hearing, she said, my son is in a box in his room. I just hate when, when things are so painful for people on public display. The community has really rallied behind this case for a long time. So, tell us what you're thinking in the chat. All right, guys, we're gonna go ahead and end the live. And we may do something tomorrow on this, just to kind of recap tomorrow evening or something. But yeah,